now I want to introduce our first presenter for today, the managing attorney over at our Winter Springs/Orlando area office, Alan Schwartzseid. Alan.
All right. Well, thank you. Between Jeff and Kirsten, I think you guys covered everything I wanted to say. You all have a nice day.
See ya. You're
No,
certified.
thank you as usual to GRS for having us here. We really appreciate the opportunity to co-host with you guys and present some education. As Kirsten mentioned, we are a full service, full state community association law firm. Beyond what she mentioned, I think it's also important that you guys understand who you're dealing with when you are being educated. Kirsten has been in this industry for years. I have been in this industry for years. We have 8 attorneys who are board certified in this particular area of law, including myself on staff, another one that's board certified in construction law. So when I say full service, a lot of firms will say that, but really they're real estate firms. Community association law is all we do. So kind of like what Courtney mentioned earlier, if you're happy with your attorney, good for you, no problem. But if you're not able to get responses from your current counsel, or if you just don't work with an attorney that you even know about, chances are they're not properly servicing you if you don't know they're even there. So bottom line, if you're not happy with them, please do feel welcome to reach out to Kirsten, reach out to me. We basically go location specific more than anything else. But if you're more comfortable with Kirsten, even if you're located next door to my office, feel free to reach out to her. So moving into the actual materials, let me share. And it would be good if I shared the right screen. I think that's what I'm supposed to do. All right. So you've now got my information, Kirsten's information, and we're going to move into the actual materials. And Kerstin really, really wanted to do this subject, but I just decided, you know what, I got to take it from her. Milestone inspections and structural integrity reserve studies, everyone's favorite topic since, 2022. I've been on 3 task forces to try and clean up this legislation, and the legislature has just done a great job of making it so that I still have lots more work to do. So there's going to be a lot that I'm going to mention does not make sense in these statutes. It won't make sense to you. It doesn't make sense to me. It doesn't make sense to all of the other attorneys who practice in this area of law, but we're required to follow it somehow. And our job is to try and interpret it for you. So I'm going to do my best. When you are filling out that Q&A and submitting questions, I want you to understand when we go through the Q&A halfway through, when I'm done with my portion, I'm not going to be answering whether your particular community needs to get these things done, because there are certain communities that don't. All right, but I want you to understand, I will answer questions about the procedure and how to decide whether your community needs to do this or not. So moving into milestone inspections. What the heck is this? Okay, a milestone inspection is essentially reviewing the structure of a building and determining whether there's a major problem that needs to be fixed immediately with the structure of your building. Now, I'm going to take a step back before we get into the real materials and explain why this all came about. Okay, if you have not been living under a rock, you probably heard of the building collapse in Surfside, Florida a couple of years ago. This was a legislative response to that building having collapsed. We now know that the things that caused that building collapse were largely construction defects and not a failure to maintain. However, the legislature still thinks that it's important to have these 2 things in place. Now, the milestone inspections, I fully support. I think this is a very important thing to do, and I don't think it should be limited to certain sizes of buildings unless it's a 1-story, because this is determining, is this building safe to live in? That's really what we're looking at. And if you can tell from a visual inspection, which is called phase 1, that there is a major problem with this building, I wouldn't want to live there, and I don't think anyone else should. Okay, so I think this stage, this milestone inspection is very important, and I think it is a great idea. And as much as it is going to cost communities a lot more money than they were spending before, I think it's something that the legislature should put in place in response to that kind of major catastrophe. The structural integrity reserve studies, I've done several speeches on why I don't think those are appropriate, necessary, or a good idea, but we'll get to that later. So moving into milestone inspections, It's essentially a structural inspection of the building, including the load-bearing elements and the primary structural members and structural systems defined in the statute. I won't go through what those are, but it's essentially, again, looking at the structure of the building and whether it is safe. These need to be performed by an architect or an engineer who are licensed in the state of Florida, or a team of professionals with an architect or engineer acting as basically the person in charge of that inspection, even if they're not on site. Okay, so bear in mind, this is different from what I'm going to tell you about a structural integrity reserve study, which must be performed by the architect or engineer directly. Now, the purpose of this is basically what I said earlier, attest to the life safety and adequacy of the structural components and to determine whether there's something that needs to be done to make this building safe. What a milestone inspection is not. We are not determining whether this building complies with the Florida Building or the Fire Safety Code. It's just looking at the structure itself. So we're not retroactively saying this is not safe and you should be required to retroactively comply with the Florida Building Code, blah, blah, blah. No, that's not what we're looking at. Is the structure sound, period. Do you need it? Now, I mentioned that only certain communities need these. Only certain buildings, in fact, need these. So it's the owner of a building that is 3 stories or more as determined by the Florida Building Code, and that's subject in whole or in part to a residential condo form of ownership that needs to comply with this requirement. Okay, so that means that purely commercial buildings do not need a milestone inspection report. Doesn't mean it's not a good idea to get one anyway, but it's not required. The other one is single family, 2-family, 3-family, or this year it was added that 4-family dwellings with 3 or fewer habitable stories above ground do not need this. Okay, so if you are, even if you're a residential condo, if you're just a single family, 2-family, 3-family, or 4-family dwelling with 3 or fewer habitable stories, you do not need this, as compared to the 3 stories or more for all other residential condo buildings. So we get into mixed use and condo hotels. This throws a little bit of a wrench as to who pays for which portions, who needs a milestone inspection, etc. It needs to be arranged by the Residential Condo Association and separately any owner of any portion of the building which isn't subject to the condo form of ownership. So if this building must have it in general, then every portion of the building must have it. Each party, each owner of those buildings, of those portions of the building, is responsible for ensuring compliance with the requirements of the milestone inspection. The association pays for the costs associated with the inspection that are attributable to portions of the building the association maintains under the declaration. Okay, so we're going to get into the governing documents later, but bottom line, your declaration of condominium is your constitution for your association. So this is the reason we put this first, is not to put you to sleep. It's because this is a crucial thing that has come out over the last few years, and everything that you are responsible for maintaining that is structural in nature, according to your declaration, is something you will need to have this for if you're required to get it for this particular building. Okay. Now, what is your responsibility under the declaration? Frankly, is a determination that your attorney should be making, in my opinion. But we'll move on to that later. When does this need to be done? Well, it needs to be done by December 31st of the year when the building reaches 30 years of age. So if you got a brand new building, you might not need this yet. Building recently was inspected, presumably, either prior to or just after turnover. But the age of the building is based on the date of the certificate of occupancy. Okay, so once that government entity issues a CO, that's when the 30-year timeline starts ticking. If you don't know when the CO was issued because your building's so old, it's 30 years from the first CO or document indicating that you can occupy this building that's found in the municipal records. Now, we talk about the 30 years, but we have to figure out what our actual deadline is if it was 60 years ago. Okay, if your building reached that 30 years before July 1st of 2022, you're required to have this milestone inspection done by December 31st of this year. Meaning, if you have not already contracted to do this, get off your butt now and take care of it. Okay, if your building, again, reached 30 years of age before July 1st, 2022. If it's after July 1st, 2022, but before the end of this year that you will reach that 30-year point, then you need to do it on December 31st of next year or sooner. Okay, so that milestone inspection, that phase one, needs to be done, not contracted for, but completed by December 31st of next year if your timeline looks like what it's stated in bullet point 3 here. You need to do another milestone inspection every 10 years after the previous one was done. So once you've done this first one, let's say you have to do it by December 31st, 2024. Let's say you do it on that date, in fact, so that we can make it easier. You would have to do another one by December 31st, 2034. Now, if you do it sooner, then you will then have to do it sooner for the following 10 years. But this is going to be an every 10-year process to make sure your building's still safe at least once every decade. Keep in mind, you may have local requirements that require you to get this done sooner or do something sooner. We'll talk about that in a minute. So, for example, I think Broward County, Miami-Dade County all have their local requirements to have a building inspected. Actually, I think it's 40 years. But if you have to do it sooner, or if your 40-year matches with the 10 years after your first milestone inspection, we'll talk about you can use those and do all of these studies together to save money for the association. Now, even though we've said you can wait the 30 years, a local enforcement agency can say that, well, it's 25 years and there are local circumstances that require that you have this inspected sooner. That might be that there was a gigantic hurricane that damaged a ton of buildings, and you may or may not have had that inspected since the hurricane, even though you think there was no damage. It could just be that you live next to seawater and that is expected to corrode your building sooner and corrode a lot of your structural elements sooner than someone who's located in the middle of Orlando. Okay, so there are environmental conditions such as proximity to salt water that a local enforcement agency can use to shorten this date. Local enforcement agency is basically your code enforcement department or some local building department. Now, that local agency can also extend the due date. I said you got to get this done. It's not just contracting for it. I say that because this is an optional extension that the local enforcement agency can provide if you're not able to get the milestone inspection done before the time that you're supposed to do it, but you've contracted for that work. The reason you might get that extension, for example, is that there are tens of thousands of condos in, I think, the US. Okay. There's a limited number of individuals and companies that are able and willing to do this milestone inspection for you. There are a bunch that we've worked with in the past. If you need a suggestion, a list, we can certainly provide that. But the bottom line is there's a limited amount of people that can perform this milestone inspection. So if you've got a contract, that is a requirement before you will get any extension. And again, it is optional if you have a contract and the inspection can't be completed before the deadline, you can ask for an extension from the local enforcement agency and they might give it to you. Some are going to be more strict than others. My recommendation, get it done in time. It doesn't matter if you have until next year to do it. I would start lining it up now, because even back 6 months ago, we were hearing that there was a 3-month delay. If you book it now, you might get it done in February. Okay, so make sure that you are pushing to get this done as needed. If you had a report that was prepared before July 1st, 2022 that actually met all of the requirements for a milestone inspection report, and we're not going to go through the details of that because frankly, you're not the one drafting it, so it won't matter what those requirements are. But if you have an inspection and a report that would substantially comply with those requirements that was done before July 1st, 2022, the association still needs to provide notice to the members and provide a copy of that report or make it accessible to the members. But if that is accepted, that previous report by the local enforcement agency, then it's presumed to be treated as a milestone inspection report and you don't need to do it again because you just did it. Now, again, this is going to be something that has to be actually approved by your local enforcement agency, not just, oh, well, we got a study done a couple years ago, so we're going to treat that as our milestone inspection report. The other thing to keep in mind, the fact that you did it early is fantastic, but that 10-year deadline to do it again is going to be from the date that that inspection was reported. So whenever that inspection is accepted, you're going to need to make sure that you track that 10-year deadline. And your manager, if you've got one, or your attorney, can help you decide, when do I need to have the next one? And my recommendation is always going to be line that up before that deadline hits, because 10 years from now, you're going to have another flood of people that got it done towards the end of this year or towards the end of next year and need to set up another one for their 10-year reunion of sorts. All right, we need a milestone inspection. Now, what the heck do we do? When you figure out that you need to have this done, the local enforcement agency must provide notice of the required inspection of the association. And the association, once you receive that notice from the local enforcement agency, which, by the way, don't wait for that notice to come out. If you know from your size of your buildings that you're going to need this, just take care of it. But bottom line, the association needs to then notify the owners of the required inspection within 14 days after you receive that notice, and provide the date the milestone inspection needs to be completed. We'll get into what that date will be in a moment. Now, there are two phases of that milestone inspection. I mentioned that phase one is going to be literally someone going over to your property, walking around and taking a look at the structure. That's it. That's the visual examination portion. Phase two will not happen unless they find something that there is significant structural damage to your building in that visual inspection. Now, if there's any chance that there's a problem, trust me, after this debacle of what happened in Surfside a couple of years ago, they are not going to take chances, and they are going to include that potential problem in their report. But if there's a report that says there is damage, you move on to phase two, which is the destructive or non-destructive testing. Now, destructive testing doesn't mean you're tearing down the building. It just means that they might be digging into the concrete to see if there are any problems and things like that. All right, now I mentioned that I'll tell you the timeline. The phase one inspection must be completed within 180 days after the owners receive written notice from the local government. So you get that notice, you've got basically 6 months to get that done. Not contracted, completed. That's phase one. Okay, if you've completion of phase one means you've got your report, it's been delivered to the local enforcement agency, and at some point the association has also produced it to the members or made it available to the members. If there's no sign of substantial structural deterioration, you do not need phase two. Substantial structural deterioration is defined here. I won't read through everything, but you're really talking about, is there something visibly wrong with the structure of your building? Okay, phase two, again, it must be performed if any substantial structural deterioration is found. And that's going to be a decision not by the board, not by your attorney, but a decision that's made by the individual or the group that does phase one. So it's going to say in phase one, we need phase two. That's it. It's not up to the board whether to get that done. It's mandatory. The phase two, again, can be destructive or non-destructive testing if it is required. Then within 180 days after submitting phase one, the architect needs to submit a progress report. Note that that means they don't have to have it completed as to phase two, because there is more that goes into this than physically looking at the building. But it means that there needs to be a progress report submitted to the local enforcement agency, and here's the important part, a timeline to complete the phase two inspection. So the inspector who completes phase two also needs to submit a written report outlining what they found in the inspection. That's going to tell you exactly what work needs to be done to shore up and keep your building safe, if any. Hopefully, there's nothing wrong, and they report, oh, we saw something, we thought it was a problem, we determined that it's not. But we're in Florida, and problems happen. Once you complete, and when I say you, I really mean the person that's performing it, completes the phase one or phase two inspection, the architect or engineer who performed that inspection needs to submit a sealed copy of the inspection report, meaning it's not something that anyone can mess with before it gets submitted, with a separate summary of the material findings to the association, any other owners. So we talked about the mixed use, the condo hotel. If there are two owners within the building, and we're talking about largely some of those that are down in Miami, some of them that are in Orlando, but you can have a residential condo inside what is basically a hotel. Okay, when you've got that set up, or it's some other mixed use, for example, you might have condos on top of shops on the first floor. That's just an example. It's not the only option for mixed use. But the owner of each component is going to have to get a copy of this. Also, the building official of the local government is going to get a copy. So it's the association who then needs to give it to the members. Any other owner, and then the building official, so that the local enforcement agency knows what you're supposed to be doing and whether everything's okay. Again, I'm not going to deal with what that report must say. You will get these materials if you complete your survey. You're welcome to take a look at this stuff. If I skip over something, that doesn't mean it doesn't matter. It just means that in reality, I'm sitting here and we're at slide 16 of 167, and I've already eaten up 20 minutes of my time. So we're just going to move on with some stuff a little faster than others. The post-milestone inspection requirement, like I said, within 45 days after receiving it, you need to distribute a copy of the summary, not the entire report, but the summary of the report to every unit owner, or let them know that, hey, this is available. You can send it via email, which is one reason that I recommend everyone's try to get people to opt into emailed notices, because this can be extremely costly if you've got a lot of members sending out any mailer. It'll make it a lot cheaper to do business overall if you can email almost every notice. And I think Kerstin will get into that email notices later. Post a copy is another thing that the association is required to do of the summary in a conspicuous place on the property. That can be inside a post board, can be at the pool or whatever amenities you have, but there needs to be a clear place that these things are posted, including meeting notices and agendas and things of that nature. That's where you should be posting this summary, and then publish the full report and summary on the association website if that is something that you are required to have. Note, and I'm sure Kerstin will get into this later, the fact that you are not required to have a website means that anytime we say, either Kerstin or I say during this presentation, you need to post it on the website. If you're not required to have one, you certainly don't need to post things on a website that doesn't have to exist. At least that's my legal opinion. The enforcement of the repairs that are needed as based in the phase 2 report is done again by the local enforcement agency. The repairs need to be started no later than 1 year after receiving the report. So if that report says you need a whole new wall, you have 1 year to commence those repairs. Doesn't mean they need to be done, although I would certainly recommend that if that's what, if you need all new balconies, I certainly would not wait a year to get that done and risk that at least one of those collapses either with someone on it or on top of someone. And that is a situation that unfortunately I have seen happen in a condo in Florida. So if you have anything in here, figure out how to get the work done as soon as possible is my recommendation. If the owner of the building does not submit proof that the repairs have been scheduled or commenced, and there is a report, the phase 2 report says that work is needed, local government must review and determine whether the building is unsafe for human occupancy. Now, note that they can do that earlier on if there's something in the report that says you got to get everyone out of this building. So don't think that just because it says here that they'll wait until that year is up, that they'll actually wait. If there is a crucial issue in the structure of the building itself, that local enforcement agency might tell you sooner, you got to get everyone out. If you don't get a milestone inspection, keep in mind, we'll talk about this fiduciary duty later, but it is the highest duty imposed by Florida law, and it's one that every director and every officer in a condo in Florida has towards the association, the corporation itself. If you don't get this milestone inspection done, it is considered a statutory breach of that fiduciary duty. Now, the reason that's important for everyone that's here today, presuming you are a director or officer of a Florida condo or co-op for that matter, that breach of fiduciary duty means you get sued personally, individually, not just the association. So make sure to take care of this. The local enforcement agency can prescribe timelines and penalties with respect to compliance with these milestone inspections. That means that in addition to the members potentially suing you personally, you can be fined by the local enforcement agency. Now, I'm not doing this or saying any of this to scare anyone. To some extent, I guess I am. But the bottom line is, if you comply with this requirement or you push to comply with it, then hopefully you won't get in trouble. And that's part of the reason that the Florida legislature decided that everyone has to take this class, because you need to be educated and understand your responsibilities, which, thank you, this is why you're here. All right, Florida Building Commission requirements. By December 31st of this year, the Building Commission is supposed to put out a safety program. I believe that's already been done. But bottom line, just comply with your obligations with respect to the milestone inspection, and you'll probably be just fine when it comes to these new requirements. Moving on, finally, to another almost identical topic, structural integrity reserve studies and mandatory reserves. So I mentioned that I don't think this should be required, and we haven't gotten into what reserves actually are. I'll cover just a little bit of that because I think Kerstin's going to cover the general topic later. But essentially, a reserve is money that you're putting away to fix, repair, maintain, or replace an association asset in the future. This isn't, you're doing the maintenance on a regular ongoing basis. This is, we won't touch this thing for 10 years. Your roof, your pavement, your painting, things of that nature that you're not doing every single year is usually what's going to go into what's called a reserve. There are statutory reserves that might exist, and there are reserves that you might have created as an association. Today, we're just going to talk about the ones, or at least I'm going to talk about the ones during this section that pertain to structural integrity reserves. Again, this is a result of the Surfside building collapse, and it's basically that the legislature, in addition to the 4 required reserves that already existed in the Florida statutes, has included a bunch of categories that they consider to be a mandatory statutory reserve for your structural integrity of your building. It's making sure that your building is safe and that you have the money to replace or repair these assets or maintain them properly when they're expected to fail. So a structural integrity reserve study is essentially going in and looking at the structure, like the milestone inspection report, but there's a different purpose here. Okay, the purpose of this one is to figure out how long is this asset going to last and what's it going to cost to maintain, repair, or replace it at the time that timeline expires. So just a quick example, if you've got a roof that's worth 100 grand and to replace that roof would cost you that 100 grand, they're going to look and say, okay, I think you've got 10 years left on that roof. Your straight line reserve, and I won't get into the details of how reserves work right now, but your straight line reserve is going to be $10,000 per year for 10 years to cover that $100,000 overall. Okay, so that's basically what's going to go into this report, but for a whole list of other items. So you're looking at all of your structural items, and keep in mind, it's only the items that the association is responsible for maintaining. Okay, if you've got the members responsible for maintaining that item, it won't go into this structural integrity reserve study. If you've got another party, again, a condo hotel, mixed use condo, etc., someone else is responsible for maintaining X, whatever it is. That X should not be included in the association structural integrity reserve study. That doesn't mean that there won't need to be another one done for that separate entity. All right, so again, I won't go through all of this, but keep in mind this last item here. Anything that has a deferred maintenance expense or replacement cost exceeding $10,000 that impacts the structure of the building, okay, or impacts any of these other structural elements, is something that is included in this structural integrity reserve study. So that includes a lot of things that aren't listed in the roof, the structure, etc. Do we need it? Again, we are talking about 3 stories or higher in height as determined by the Florida Building Code. So that's your criteria for both of these reports as to whether you need it. 3 stories or higher as determined by the Florida Building Code. Now, we say as determined by the Florida Building Code because there used to be a question of, well, we've got, 2 stories of livable space, but we've also got underneath those 2 stories, we've got a parking garage. Okay, we're going to look at the Florida Building Code and not just logic to determine whether or not you need to comply with this requirement. Now, this needs to be complied with at least every 10 years after the condo's creation for every building on the property. Okay, now I say every building on the property, everyone that's 3 stories or higher. So there are exclusions to this. If there's a building in your condo that's less than 3 stories, that building does not require it, even if other buildings in your condo are larger than that. For example, you've got a clubhouse that's separate and apart from the rest of the condo buildings, and that clubhouse is only 2 stories or only 1 story. You don't need a structural integrity reserve study for that clubhouse. It is not 3 stories or higher. Again, single family, 2 family, or 3 family dwellings with 3 or fewer habitable stories above ground. any portion of the building that's not part of the residential condo, any portion of a component that's maintained by someone else. Again, when your unit owners are maintaining these. And a commercial condo in total does not need to comply with this. Again, this is a residential condo issue. Now, the fact that it's a commercial condo and doesn't need to comply, I don't quite understand. If you're going to require it for people that live there, why not people that work there for 10, 12 hours a day? But that's what the legislature decided, and I'm certainly not going to fight it because I don't really agree with these studies anyway, other than the milestone inspection report. Now, it's based on a visual inspection, just like phase 1 of the milestone inspection, and there's a reason for why I mention it that way. You can technically do both as one study if the person that's performing it is qualified to do both and is willing to put the information that's required for both studies into one report. So if you're doing it, you can do all of it together, which frankly will save you some money. Here's what it needs to include. Again, I'm not going to go through everything that needs to be in this study because you're not the one preparing it. Who can perform it? Again, it's not just it is just the engineer and the architect, but rather than a group that's supported by the engineer and architect, this needs to be a reserve specialist or professional reserve analyst. Okay, it's someone who is specially qualified to analyze these reserves, not just someone who is, leading a team. And that's the visual inspection portion, by the way, that is done by these 3 individuals or these 3 categories of individuals. The deadline to complete this for a building that existed on or before July 1st, 2022, which is unit owner controlled, meaning it is not developer controlled. This needs to be done by December 31st of this year. Again, these are requirements that have been in place since 2022. If you haven't gotten to work on it yet, I strongly recommend you get to it as soon as you get off this webinar. And again, this is for each building 3 stories or higher in the community. However, an association required to complete a milestone inspection before December 31st, 2026 can do both of these together, like I mentioned a moment ago. Okay, but the structural integrity reserve study cannot be completed after December 31st of 2026, even if that's the way you're doing it. So if you're going to do them combined and you're not going to comply by the end of this year because you don't need your milestone inspection yet, you're going to make sure that by the end of not next year, the following year, these are both done, not just one or the other. If you need to have it or you had an inspection completed for a similar local requirement like the ones I mentioned earlier for Broward and Miami-Dade, and it was done in the last 5 years and meets all the requirements for the structural integrity reserve study, you can use that in place of the visual inspection portion of the structural integrity reserve study. Note what this doesn't say. It doesn't say you can use it to decide what the reserves are. You just don't have to have someone again physically come out to your building and take a look at it unless you want to get a more accurate picture of what it looks like now. You're going to be spending more money to get that accurate picture. So some communities will say, we'll just go with what we had before and adjust for inflation instead. Okay, we've done this. Now what do we do? We've got the report. Great. The study is done. Well, again, within 45 days after receiving it, the association needs to distribute a copy or provide a notice that the completed study is available for inspection and copying. The copy needs to be sent by U.S. mail or personal delivery. Again, you can use electronic transmission for people that have opted into electronic transmission. What I mean by that is email or fax. You also need to provide, this time it's the division. Jeff mentioned the division earlier. This is basically the DBPR. It's a state entity that needs to be notified that you have complied with this requirement. There is a website that's set up. I think, Jeff, you might have that link if you can share it. If not, I can share it when I'm done with my portion of the presentation.
I'll put it in the chat in just a second.
Okay, thank you. These studies need to be maintained in your official records for at least 15 years after the study is completed. We'll go through what official records are later. Most of them need to be kept indefinitely. This one has a specific timeline on it of 15 years. For associations that need to have a website, again, if you don't need to have one, you don't need to put it up there. If you do need to have a website, then you need to post this on the website as well. Don't worry, this is all going to be behind login credentials, so only your members can access the document. If you don't do this, again, breach of fiduciary duty, not good, very bad, have a bad day. So bottom line, please comply. If the association needs to have this done, the reserves need to be maintained for the structural integrity reserve study items the association is responsible to maintain pursuant to the declaration. What does this mean? If you have an item that you're responsible to maintain, the reserve study says, here's what you need to be putting away, you need to actually do that. It's non-negotiable. The only way you can get away with not doing it is by paying someone else to do a different reserve study that you think for some reason is going to come up with a different result. Okay, I don't recommend that. And I think that you then have competing studies that someone could use against the association in court potentially. But bottom line, it's your risk to take, not mine. The reserve amount for each item needs to be based on the actual recommendations that are in the study. You do not have discretion to say, I disagree with what this is going to cost going forward. You have to use what's in the reserve study. So bottom line, use a reserve study specialist that you actually trust to get it right. The association can adjust replacement reserves to take into account inflation and any changes in estimates based on work that you've done. Changes in the estimated useful life, if you think that it's going to be needed sooner, can also be accounted for. Reserves exemption, if the item can't be determined how long this thing's going to last, because it's going to last, indefinitely, but it's part of your structure, or if the life expectancy is more than 25 years. For example, you've got a 40-year roof on a condo building. You do not need to include that in your reserves. But if the structural integrity reserve study recommends that you do so anyway, you'll still need to put that money away. Waiving and reducing reserves has also changed. So for those of you who don't know what waiving and reducing reserves means, you have a set amount of reserves. That's called full funding. That's basically everything we think that we'll need based on our most recent reserve study, we're going to put away. Okay, someone has told us what it's going to cost and when we're going to need that money to repair, replace, or maintain that specific asset of the association. We're going to put that money in our budget. It's going to say, hey, we're putting away X amount for the roof, X amount for this, X amount for that. You might have a pooled reserve. We'll get into that later. But the bottom line is, this is money that you're required to put away unless you have a member vote. There is now a distinction between the non-CEUs reserves, so the ones that are not for the structure of the building, and the ones that the government is now telling you that you need to put away for the structure of the building. Now, the non-CEUs reserves, including taking money from those non-CEUs reserves and putting it into the CEUs reserves, and CEUs is the Structural Integrity Reserve Study, for those that I didn't clarify that for, I apologize. And I'm saying it frankly to be faster because we're already pushing time. If you are in a unit owner controlled association, a majority vote of the total voting interests is now what's required. When I say the total voting interests, I mean the entire community, a majority of every unit, okay, except for those that have been suspended for voting purposes, needs to vote in favor of either using these funds for another purpose, waiving them, meaning you're not going to put them into your budget this year, or reducing them to a lower figure. Okay, if you're doing any of those three things, you need a majority vote of the total voting interests. And you can only do that for the things that are not considered structural reserves. We call those little g reserves because of where they're located within the Florida statutes. Okay, the CEUs reserves for any budget adopted on or after December 31st of this year, you cannot reduce, you cannot waive CEUs reserves, and you cannot use them for any other purpose. And we talk about alternative funding methods here, but that only applies to a multi-condo association operating at least 25 condominiums. There are very few of those in the state, and if you're operating one, feel free to reach out to me separately if you need guidance on this. I know of only one in my local area that I've been speaking with. So bottom line, that probably doesn't apply to you. If it does, just reach out and I'll be happy to work with you to the extent that I can. Using reserves for a different purpose, again, majority of all voting interests, but you cannot do that for the CEUs reserves. Pooling in general, there's nothing in the Florida statutes that says you can combine all of these reserves for the structural integrity reserves into a pool, meaning that you're not saving on a straight line basis like I described earlier, that 10 grand a year for that roof. What you're putting aside in a pool is just what you'll need the next time an asset that's included in the pool is expected to fail or need money. So what you're doing is your roof, your paving, all of it goes, well, not your roof and paving, but your roof, your windows, your doors, all of that goes into one pool of reserves. And the next item you expect to fail is what you're saving for. As soon as that item is failing and done, you start saving for the next item that's expected to fail. So what it really means is you're putting away less every year. In the pool, you can't, the statutes, again, are not clear whether you can pull structural integrity reserves. Get advice from your attorney. And this is not so we make more money, by the way. This is so that you have something in writing to say, I relied on advice of counsel and thinking this was okay, if someone decides suddenly that it's not. There's nothing in the statute that says you can't. The problem is there's nothing in the statute that says you can. That's one of the things that the task force I'm currently serving on will be trying to put into the statute, but it's not there yet. Now, we talk about local government intervention. There's new laws that became effective July 1st of this year. If the building is uninhabitable due to a natural emergency or for other reasons, the board, upon approval of a majority of the members, can pause contributions or reduce these reserves. So I said you can't stop paying these reserves for structural integrity. You can do it if there is a determination by a local building official that your building is uninhabitable. Now, keep in mind, that doesn't mean it looks bad. It doesn't mean that there's a problem. It means literally no one can live in your building. And the purpose of this is to make the building habitable again. So you're not going to be putting money away for your roof if that's not problematic and it's not expected to fail, and you can't live in your building until you do work on the staircase that's falling apart. Okay. So this, again, requires the local building official to make that determination before you're able to pause, reduce, or eliminate your reserves or your CEUs reserves. Reserve funds held by the association can be expended pursuant to the board's determination if you've got that local building official approval and your majority of your member approval to make the building and its structures habitable. Once the building's habitable, you go back to immediately funding the reserves in full. Okay, what else? Developers are required to provide CERS. So regardless of when the certificate of occupancy was issued or the height of the building, a developer needs to include a structural integrity reserve study with the turnover inspection report. What does this mean? When the developer is handing over all the documents because the members are now taking control of the board and you've had your turnover meeting and the members are saying, okay, this is our building now. You still have a couple units left maybe, but you're not in control anymore. Once that happens, the developer has a list of items that they need to turn over. This is now one of them. So they're getting their own structural integrity reserve study, regardless of what the association is required to do later on. Unit owner disclosures is not really something that the association has to do, hence the title, but it is something we thought worth mentioning. If the sale is entered, the sales contract is entered into after the end of this year, it needs to contain a specific disclosure regarding milestone inspections and structural integrity reserve studies. If that's not provided, you may lose your contract. So that's something to take up with your real estate attorney, but I thought it was worth mentioning, and apparently so did the legislature. If the association must perform the milestone inspection and hasn't completed it, then your contract needs to contain certain language. If you have completed it, then the contract must contain conspicuous statement with other disclosures. So again, not going to go into detail as to what those disclosures are. Just know that if you are selling your property and you're using a realtor, not a lawyer, they may not be aware of these requirements, and you want to make sure that you work with either a real estate lawyer or a realtor who takes classes like this to be aware of those requirements. I'm going to skip that. Disputes regarding the milestone inspection. Now, this is effective July 1st, 2027. So as of right now, if an association is required to have a milestone inspection, there's really nothing that specifies what needs to be done. Technically, my opinion means, or in that instance, is that the members can report it to the local enforcement agency or the DBPR as appropriate, and hopefully they will do something with it. As of July 1st, 2027, we're going to the same procedure that is used for other covenant enforcement matters. Essentially, you will send an offer for pre-suit mediation as to the failure to obtain these structural integrity reserve studies and milestone inspections. And then you might file a lawsuit if the association doesn't comply and reach an agreement by the time that that mediation happens, or they don't respond to your offer for pre-suit mediation. It's not subject to mandatory binding arbitration. It's not subject to non-binding arbitration. This is as compared to other covenant enforcement, and we do have separate classes on covenant enforcement, so I won't get to this in detail, but I do recommend checking out the covenant enforceability for HOAs and condos class at our website, kbrlegal.com, under the calendar. I'm sorry, we don't have one scheduled, so it's not the calendar, but it is the resources tab, which is where this class will also be posted probably sometime next week. So that's something I would definitely check out, and we will move on from there. Topic 2, we've made it through topic 1 in less than an hour. Congratulations, everyone. You should be very proud of me. Oh, I mean yourselves. Topic 2, so we're talking about elections, which is a very strict process. Fortunately, I get all the boring stuff and Kerstin gets everything that's fun today. And official records, like I mentioned earlier, and record keeping. All right, so we're going to start with elections. Now, in an HOA, an election is a fairly difficult practice. You really are looking at your documents and figuring out what's going on and figuring out, do we need to take people's nominations from the floor? Do we need to get an election committee together? What are we going to do? In a condo, fortunately, they all work the same. Now, I say that just to understand there was a recent ruling by the DBPR, by an arbitrator, and it's by the state, which is not precedential, meaning that a judge doesn't have to follow it and neither does another arbitrator or even the same arbitrator in the future. But there was a ruling that you might need to go by your bylaws, even though it's been clear to everyone in Florida for 20, 30 years, or however long this statutory election procedure has been in place, that this is what we have to do. My recommendation, follow the procedures that's set out in the statute, in the Florida Administrative Code, and in these slides, because in reality, if that goes wrong, it's because the arbitrator ruled improperly, in my opinion. All right. So if you have a vacancy on the board that's caused by the expiration of a director's term, that must be filled by electing a new board member. So let's get into what is the board. Okay, there are 3 hats you might be wearing in your community. 1, you're a member, you're a unit owner. That's all that means. You own a unit in the condo. That's a member. A director and an officer are completely different concepts, even if they're the same people. So this is very important for the board to understand. It's important for everyone to understand, frankly. The board is comprised of the people who are elected by the members or appointed by the other directors. The directors do nothing other than hold meetings, make motions, second motions, and vote on or abstain from voting on motions. That abstention should only be because of a conflict of interest. But that's all a director does. They're the people that show up to board meetings, vote, and make decisions. And honestly, it's like 90% of the decisions of the association that will be made by the board and not the members. I know that's surprising to a lot of people, but that's usually how a corporation operates. Okay, so what we are going to be doing is the board makes the decisions. The officers, the president is not the board president. Okay, I hear that used very frequently. The president is the president of a corporation. You are running a business, whether you know it or believe it or not. Okay, 99% or more of condos that are residential in Florida are not-for-profit corporations. That is the business that you are running as a director. The officers are the president, who has specific duties, usually the mouthpiece, the person that signs the documents, etc. The vice president, who really doesn't have to do anything, but they have some responsibilities if the president isn't available. The secretary, who, if you have a manager, that person's probably doing your job, but really that's the person that maintains the records that we'll talk about in a minute and keeps the meeting minutes. And the treasurer, who deals with the money. Those are officer positions. Officers do not vote. The directors get to vote. So just understand there is a distinction between one and the other. So moving back to this is deciding on the directors. Okay, when you have your election, you're not deciding officers. The board, the directors decide on the officers, The members decide on the directors. Okay, so again, vacancy caused by expiration of a term, filled by electing a new member of the board. Vacancy caused before the expiration of a term, so someone resigns, they're disqualified, they're suspended, they're removed, except by a recall, is filled by a majority of the directors that are remaining after that person comes off. So all they have to do is appoint someone. Alternatively, they can hold an election to fill that vacancy. My recommendation is you'll see how complicated and time consuming and costly this election process can be. Well, maybe not so complicated, but time consuming and costly. I have zero inclination to tell any client to hold a second election unless it's absolutely required. If the board can literally have a meeting or have a written unanimous resolution to appoint another director, why would you spend the time and the money to hold another election with all these notices that we'll talk about in a minute? I just don't see the point. All right, so we'll talk about the timeline. Most of the deadlines are listed here. I'm going to go through them relatively quickly. Not less than 60 days before the election, you send what's called your first notice. It's essentially, hey, we're having our election. Here's the date, time, and location. Be ready. And if you want to serve as a nominee for the board, meaning that you are to be considered among all those people that are interested in serving, all two of them, then you need to submit your notice of candidacy at least 40 days before the scheduled election. Okay, so again, this first notice says you are going to have an election and you have basically until 40 days before that election to submit your notice that you want to be a candidate. If that is provided by the candidate and they want to be on the board, great. They should be getting some kind of receipt from the association that the association actually received the notice. And then the candidate can provide at least 35 days before the election an 8.5 by 11 sheet to be included with the last notice of the election that'll be mailed out, and it basically gives the information that they want the members to know about that candidate. Not less than 14 days or more than 34 days. This is to provide time for the nominees to get that information sheet in. Not less than 14 days nor before more than 34 days before the meeting itself. There is a final notice, which is the second notice, sent along with the written notice of the meeting, the agenda for the meeting, as well as the documents, the ballot that lists all the candidates alphabetically by last name. So understand, you're not going to distinguish between who's on the board now and who's going to be on the board unless you've got, well, never mind. I was going to mention something that doesn't apply, so let's skip that. But you're not going to mention them in order of how much you like them. You're not going to mention them by first name. There is a statutory requirement as to how people are listed on the ballot. So that notice is going to go out at least 14 days before the actual election meeting. Now, the number of directors, unless your bylaws generally, maybe your declaration or your articles say otherwise, you have a 5-member board in a condo, unless you have 5 or fewer units, and then the board is going to be at least 3 people, can be up to those 5. If the articles or bylaws, and let me go through what these documents are, even though it's not in this section, the articles of incorporation basically create the company that you are running as a director. They're basically going to say the purpose of the association, which is to maintain and operate a condominium association. And that's really all that's in there most of the time. The bylaws are going to be your kind of guidebook as to how the procedures are going to work in your community. The other one that is the top dog that I mentioned earlier, basically your constitution, is your declaration of condominium. That's going to go by day-to-day operation, rules and requirements, your right to collect and foreclose for assessments, etc. All right, so if the articles and bylaws permit the directors to serve for terms of longer than 1 year, the terms of all directors expire at the annual meeting unless the condo is a timeshare or non-residential condo, or the staggered term of a board member hasn't expired yet. So if you've got a 2-year term, you don't go and have that person even listed or that slot listed at the next election. That person just stays on the board for the remainder of their term, and they're not listed. They don't have to try again, even though their term's not over. All directors' terms would otherwise expire, but there are no candidates. You don't need an election. Okay, that's called an election by acclamation. Everyone would be having their terms expire, but no one other than those individuals put their nominations in. Okay, they're still in. And from my perspective, I know people will disagree with this, but if you don't have anyone else put their name in the hat and none of the directors did either, even though their terms have expired, they just roll over to avoid a receivership. And a receivership is basically having someone charging you the rate of an attorney to do the job of your manager and their hourly rate, not just a bulk monthly rate per unit in your condo. There are term limits that have not officially kicked in yet. So board service that has started after July 1st, 2018 is what you're going to use for these term limits. Now, a director can't serve more than 8 consecutive years starting July 1st, 2018. So if you were already on the board, you stay on until July 1st, 2026. Unless that service that is extended is approved by 2/3 of all votes cast in the election, or there aren't enough eligible candidates to fill the vacancies on the board. The way that I've seen people getting around this, although not necessarily my recommendation, is I want to stay on the board. I resign before the end of my term. I am reappointed to the board before the election, and there's no one that wants to serve. So I'm still on, and my 8-year term has started over now. Again, can't recommend that you do that, but it could work. In a residential condo of more than 10 units, co-owners of a unit, that includes spouses, can't serve as directors at the same time unless they own more than one unit, meaning that they have the right to serve on behalf of more than one unit, or there are not enough eligible candidates to fill vacancies on the board at the time of the vacancy. Again, election by acclamation is essentially where you've got the number of vacancies is the same or less than the number of candidates, meaning you don't have enough people to fill the board, even if everyone was shoved on there. So at that point, you don't have an election. It's just whoever put their name in the hat is on the board. If there's no quorum requirement for a condo election, but at least 20% of the eligible voters must cast a ballot, not just show up, but actually cast a ballot in order to have a valid election in a condo. Whoever gets the most votes wins. That's how you do the calculation. The ballot sign-in sheets and everything else relating to the election does need to be kept in the official records of the association for at least 1 year after the date of the election or whatever other vote was taken. And then any challenge to the election process, meaning someone says, oh, you did this part wrong, you didn't provide this notice to everyone, or the wrong person was listed on the ballot or was not listed on the ballot, or this person wasn't eligible to serve and you listed them anyway, that needs to be brought within 60 days after the election results are announced. Eligibility. So a candidate is an eligible person who's timely submitted a written notice of intent to become a candidate. If you didn't submit that notice within that 40-day timeline before that election meeting, you are not an eligible candidate because you didn't say you wanted to be. That doesn't mean you can't be appointed later, but you will not be listed on the ballot if you did not submit at least the notice of intent form. Anyone that wants to be a candidate must be eligible to be a candidate to serve at the time of the deadline to submit. So that's not the election meeting itself. That's going to be that 40-day timeline. So anyone that is not eligible as of that date does not get listed on the ballot, even if they submitted their notice. A person who's delinquent in payment of any assessment due to the association as of the deadline to submit the intent to be a candidate is not eligible to be a candidate, period. Someone who's been suspended or removed from directorship, even in another community, by the division under the Condo Act is not eligible to be a candidate. There are reasons that we'll get into later as to why you might be removed as a director. Someone who's been convicted of a felony and hasn't had their civil rights restored, and that's a felony in Florida or something that would be in a felony if it had occurred in Florida, is not eligible to serve. So again, those civil rights being restored basically means you've been out of prison for at least 5 years as of the date you seek election. If the association doesn't have a criminal background check procedure, which is many condos in Florida, and doesn't know about that felony conviction and release date, and the person wouldn't have been eligible, then it's kind of a no harm, no foul. The fact that they weren't eligible, if you find out later, doesn't mean that anything that person did while on the board is somehow invalidated. It just means you pull them off now because they weren't eligible. or if a criminal charge is pending against an officer or director related to community association issues, they also can't be appointed or elected, and may not have access to the records of the association except pursuant to court order. Meaning, when they do a records inspection, you don't have to provide those records if you are aware of that pending charge. And it's not just someone in the community said, hey, he stole money. It is an actual criminal charge issued by a prosecuting attorney. Voting by secret ballot is generally the way that you do you do your election. You cannot have a proxy, limited, or general as part of the election. That's because the ballot is already set. Just submit your ballot. You don't need a proxy to let someone else vote on your behalf. You just fill it out and give them your ballot. An election ballot is cast, and we'll get into giving them your ballot and what that means at a later time. An election ballot's cast using an inner envelope and outer envelope addressed to the person. So basically what you're doing, and I'll go through it as quickly as I can, you're taking that inner envelope that has the ballot inside it. You are closing that inner envelope, and there is no marking on it to show who is voting. That's how you separate out so that this is a secret process. Now, if there is something written on it, if someone wrote their name on it, if someone wrote their name on the ballot, my perspective is you count that vote, but that person has waived their anonymity. They're telling you how they're voting, and that's okay. Okay, but it's their right to vote in a way that will keep that secret. So again, ballot goes inside the inner envelope with no markings. The ballot is marked only as to how they vote. The outer envelope has the inner envelope inside it, and that outer envelope is where you're going to mark down, here's who's voting, here's the unit number, the name, and the signature, etc. When you're actually counting the ballots, my recommendation, stop the balloting, make an announcement that and actually have a board vote or a vote at the meeting that you are going to stop the balloting. That means that you can start counting without risking that someone's going to come and submit another ballot when you're in the middle of counting them, and you would know who that is. You start by opening the outer envelopes and separating them from the inner envelopes, and then putting the outer envelopes away completely, generally in a box somewhere. Then you open the inner envelopes and separate the ballots from the inner envelopes and put the inner envelopes in that box. Then you start counting the ballots. And again, whoever gets the most votes wins. That's essentially what it's going to be. Each inner envelope can only have one ballot. If a member is entitled to cast more than one ballot, they need separate inner envelopes. Any inner envelope that has, and that's the first envelope, the smaller one, if that has more than one ballot in it, neither ballot will be counted. They will be discarded, and you write discarded right on it. I generally suggest writing the reason it was discarded so that there's no question as to why and that it was appropriate. If the outer envelope doesn't have sufficient information to verify who's supposed to be voting and that they haven't already voted all of their votes, then that outer envelope, in my opinion, should be discarded as well. So you're making sure you're checking it against your registry of who is entitled to vote to make sure that the outer envelopes are good. Now, you can have that meeting to evaluate those outer envelopes before the election takes place. Keep everything secure, keep it all together, but you can verify that the outer envelopes in and of themselves are good so that you don't need to do that during the election meeting when everyone is there. All right, we went through most of this. Someone who needs assistance in casting the ballot for the reasons stated in, and this is basically a disability, can obtain that assistance. It's okay to help someone, but a unit owner can't authorize someone else to vote for them. Okay, you would be just submitting this. It's fairly simple. You send the outer envelope or drop it off at the association office or wherever it's supposed to be, generally with the secretary or the manager. I talked about verifying the outer envelopes. That meeting is open to all the members if you're going to hold a separate meeting, and it needs to be an impartial committee consisting of members who are not current directors, officers, candidates, or any of their spouses. So this is a separate group that can be appointed by the board or can be requested by the board, but it is a separate group that has no interest in the outcome of the election, that is going to check off and make sure that these ballots are to be counted. Any outer envelope that's not signed by the eligible voter should also be marked disregarded, or with words of similar import. And any ballots that are in those outer envelopes shouldn't be counted. Now, anyone who engages in a fraudulent voting activity, and by the way, that includes helping someone to commit voter fraud commits a first-degree misdemeanor. Now, that is a crime, just to be clear. There are several items that the legislature has decided should be criminalized. I think they should be major monetary penalties, but again, we don't get to decide what the legislature does. Forgery of a ballot envelope or voting certificate used in a condo election is punishable as a third-degree felony. So there's a difference between voter fraud and forgery of a ballot envelope or voting certificate. In other words, if you're voting on someone's behalf illegally, that's a third-degree felony. If you're just using threats, bribery, or intimidation, that's a first-degree misdemeanor. Electronic voting can be a fantastic thing for your community. I'm not going to go through the details because all of the vendors that do this are the ones that are really responsible for 99% of this. The thing that we do is generally we'll put you in touch with a good vendor who we've worked with in the past. Again, we don't really make recommendations, but we can put you in touch with people. You make your own decision. But electronic voting is essentially where someone can load up an app or load up a website and vote that way instead of having to fill out that ballot in person or, pardon me, in writing. And there are so many people, especially younger generations, that just are not willing to take the time to fill out that ballot, put it in the outer envelope, put it in the inner envelope in reverse order, and send it on to the association that would be willing, if they just had to click through an app on their phone, to vote in 30 seconds. Now, electronic voting requires a couple things that we will give guidance on. One is that you need an actual board resolution made at a board meeting notice at least 14 days before the meeting for which you want to use the electronic voting. The other thing is that each member needs to opt in to voting electronically. You can't just say we're using this now and expect that everyone is going to be obligated to do it. Now, what this does, yes, it's an additional expense for the association, but usually, depending on the vendor and what they charge, that'll cancel out the cost of mailing this notice to the people that are voting electronically. And the vendor, if they're doing it the right way, in my opinion, will be the one to go out and try and push everyone to opt in, because that basically determines what they get paid. So I'll skip the rest of electronic voting, but I do think that it's very important to understand that that's an option, because at that point, if you've got everyone voting electronically, you really can hold your meeting purely virtually. If not, you might need to actually have what we call a hybrid meeting, where people can attend virtually, but you also are providing an in-person venue. The officers we talked about. Now, one thing that I want to mention that I didn't before, the officers, again, your president, vice president, treasurer, secretary, these are people that are elected by the board in the organizational meeting that occurs right after the election. These are not the people that the members get to vote on. The only thing the members get to vote on is who is on the board, who are the directors. Then the board gets to decide in the only secret meeting that the board is allowed to hold throughout the entire year who the officers will be. Now, as a practical matter, 99% of the time, this is actually held as a, hey, John, you want to be president? Yeah, sounds good. All in favor? Aye. All opposed? Nobody. Great. John's the president. It's usually that simple, and this meeting takes about 5 minutes to organize who the officers are. But that is something that I needed to mention, that everything else needs to be decided out in the open to some extent. The board does not get to decide anything other than who the officers are by secret ballot. The board can't decide anything by email, or actually they can't vote via email, but decisions can be made separately. Kerstin will get into that later. The other important thing to point out regarding the officers, because the board gets to decide who they are, you can change up who the officers are midstream, meaning in the middle of the year, a week after you decided who the president is going to be, if they've been knocking on doors, yelling at people, telling them to stop violating the association rules, and you don't want to get in legal trouble, and they will not listen when even your attorney tells them you need to cut this out, or they're just unruly and won't listen to anyone and they think they're in charge, they're going rogue, so to speak, you can just decide as a board, and if you've got a 5-member board, then 4 of you need to show up at that meeting and vote that person out as the president. They can either be put in a separate role, whether it's vice president, treasurer, secretary, or they can just not have an officer position at all. It doesn't matter. It's up to the board. Now, there are things that will disqualify you from service. In other words, it'll get you kicked off the board. Okay, a kickback. is a third-degree felony. A kickback is basically accepting something from someone who's proposing to do business with the association, and with the implication, at least, that you're offering to sign that contract or vote in favor of that contract in exchange for getting this individual benefit. Okay, it could be that someone says, oh yeah, I'll mow your lawn first out of all the homes in the community. I'll paint your unit if you sign with us, and I won't charge you for it. I'll give you a discount. That discount in and of itself is enough that this can't be done. The other thing you can't generally do is accept things that are not part of a business meeting or a trade show. Okay, so just be careful with what is and is not a kickback. Don't accept them. Don't go to jail. Do not pass go. An officer or director charged, again, by information or indictment by any crime that's outlined in the Condo statute is removed from office. If the charges are dropped or there is a finding of no guilt, they are reinstated if their term hasn't already ended. Okay, so if you have someone who's charged with a crime related to the association, they're off the board. It's kind of a suspension, it's kind of not. Because if their term's over by the time that suspension would have been lifted, they don't get to just jump back in and take over the person that was elected or appointed after them. An officer or director who's more than 90 days delinquent in payment of any monetary obligation due to the association is considered to have abandoned their seat on the board, creating a vacancy, meaning they're off completely. They've abandoned their seat. That's the only thing I'm aware of that will cause someone to be treated as having abandoned their seat on the board. And again, that's someone who is in a position of power and trust within the community that has a fiduciary duty and is doing the exact opposite of that by making everyone else responsible for the assessments they should have paid. Now, I say assessments. Again, this says any monetary obligation. That could be a fine. It could be a rekeying charge. It could be a new key fob that they got that they haven't paid for. But if it's more than 90 days delinquent, and note that I didn't say 90 days past due. I said 90 days delinquent, which may be defined differently in your declaration. So you want to run that by your attorney before you unilaterally decide they're off the board. If you willfully violate the records inspection requirements 2 or more times within a 12-month period, that is a second-degree misdemeanor, and they're out. I will discuss the records inspections in a minute. Anyone who knowingly defaces or destroyed accounting records or fails to create or maintain them in furtherance of potential crimes, and anyone who willfully and knowingly refuses to release association records in furtherance of a crime. In other words, I'm trying to cover this up. There was a separate crime, and I'm hiding it by basically destroying the records that the association might have to prove that I did something wrong. Any person who uses a debit card, and this is the important part, issued in the name of the association or billed directly to the association, unless you've gotten a written set of meeting minutes approved or it's in the written budget before you spend the money. Okay, bottom line, to get around this one, use a credit card and you don't have to deal with this law. I don't understand why there's a distinction, but as of right now, you can use a credit card in the name of the association and you will not have to deal with this. The alternative, you spend the money on your own credit card in your name that is not billed directly to the association and ask for reimbursement, and the board approves that reimbursement instead. That's okay as well under the law. If the board finds that a director or officer violated conflict of interest requirements, they are deemed removed from office. There is a complete vacancy, and a director who fails to timely file the written certification that you will get today on top of signing the little piece of paper that doesn't mean anything, that says you've read and will do your best to uphold what's required by the governing documents. Those 2 things need to be with your secretary or your manager, whoever maintains your official records. Otherwise, you are considered off the board. Now, I mentioned earlier, that is if you do not, maybe I didn't, this is organized differently, sorry. So within 90 days after being elected or appointed to the board, you have to take this class, file your certificate with the association, and also sign a piece of paper that says, I'll do my best. And that needs to be filed with the association. If within those 90 days you haven't done it, you're technically suspended from service until you complete that requirement and get the records to the manager or the secretary, whoever maintains those. I talked about condo websites earlier. You need to have one now if you have 150 or more units. If you have 25 or more units, you will also need to have one effective January 1st, 2026. So in an HOA, you have to have this by January 1st of this coming year. You have another year to get this done, but keep in mind, most of the firms that are doing these websites are already backed up. So I would look into it now if you are between that 25 to 150 mark. If you have less than 25 units, you do not have to have one, but you can. My opinion is if you have less than 25 units, you probably are not required to comply with these requirements that I'll mention earlier. So if you're in a smaller condo, you might not need to comply. My recommendation is that you comply anyway, because it'll make your life easier to put all this stuff up on the website, because you can direct the owners to the website instead of answering questions a lot of times. So the website needs to be independent, or a website or web portal wholly owned and operated by the association, or it can be done by a third-party provider, including your management firm. And Courtney, if you can clarify whenever you have time to jump on, I think GRS is providing this option through the portal for its clients, but let me know if I'm mistaken, please.
We are providing it. Yes, we started
That's what I
building.
thought. See, GRS
Yes,
makes it
we are
easy.
providing it.
Perfect. Thank you, Courtney.
No worries.
So if you're working with GRS, this is probably something you already have. A lot of management firms, I'll say probably most, are charging a little bit extra to create the portal that's required beyond just here's the records, because there are new requirements for what needs to go on the front page, so to speak, of this website. So understand, just because your manager is charging more, it just means it's because they're doing more work. The association website needs to be accessible through the internet, needs to have a subpage that is protected by password and username. There are most of your documents, and I'll go through, because keep in mind, this is almost everything that is listed here as an official record of the association, which I'll go through later. But it also includes your rules, regulations, governing documents, all contracts that are current, summaries of bids that exceed $500 for 1 year. In lieu of complete summaries, or I'm sorry, in lieu of summaries, complete copies of the bids can be posted instead. Again, all of this stuff is going to be an official record, official records, official records. Not having these items does not invalidate any board action. So the fact that you didn't post something means that you did it wrong. It doesn't mean that a decision doesn't count, is really what that means. An association needs to designate a person or entity with a street or email address to get estoppel certificate requests. That needs to be on the website. You also need to ensure that the information and records that are not accessible to unit owners, we'll get into those later, are not posted on the website. Now, they can be posted as long as they're behind separate login credentials that only apply to current directors and officers. So understand that this doesn't mean you can't have it that's accessible online. It means that it can't be the same link that's given to every member. Protected information is included in the documents that are required to be posted. The association needs to ensure the information is redacted. I dealt with a redaction just this week where someone was demanding full copies of bank statements, and not all the information that was in there was subject to disclosure. There's no liability if you inadvertently disclose something that shouldn't have been given out. You can use a mobile app. I only know of like 3 communities in Florida that are using an app instead of a website. My recommendation to make it easier, there are companies that will set up an app that basically just mirrors your website so that people can have a link on the front of their phone instead of just going to your website and doing the exact same thing. I don't have a problem with using that. Okay, moving on to official records, which I believe might be the last thing that I'm going to cover with you all today, but we'll see. I'll be happily surprised if there's more. Can't promise you'll be happily surprised, but here we go. The official records are comprised of a list of a bunch of stuff. And the reason that I'm saying a bunch of stuff is that we skip everything and we look at number 19 here. All other written records not specifically included in the statute, the things included in the statute are the ones that are listed above here, that relate to the operation of the association. That's literally everything that pertains to your business. Okay, so the official records are everything. Anything written is going to be an official record. Now, I've had people ask, well, what about emails? That's written in my opinion, and there are DBPR arbitration orders that say that is a written record and should be included in the records of a condo. If it's just a digital record, that does not mean, in my opinion, especially in 2024, that you do not need to include that in your official records. So that is something that probably should be on the website or accessible in the official records. There is a minimum retention period. All official records must be maintained for 7 years, but there are certain things you need to maintain since the inception of the association. Okay, that's your plans, permits, warranties, and other items provided by the developer. So the developer turnover documents, copy of the declaration bylaws and all amendments, the articles of incorporation and all amendments, all rules, current rules, not the old ones, all meeting minutes. Now, keep in mind, rules is going to include any architectural criteria you might have, any policies that you've enacted, etc. So all of that is going to be maintained permanently. Now, it's only the current rules, but that's going to be permanent, not the 7 years, but forever. We mentioned CEUs and inspection reports need to be maintained for 15 years. Bids for work to be performed are kept for 1 year. Ballots and other election documents are kept for 1 year. And I am breezing through this, but keep in mind, you'll get a copy. So don't freak out that you didn't write all this down. The official records need to be maintained in an organized manner that facilitates inspection by a unit owner. This is new and obnoxious. It was never required. It used to be that you had a bunch of boxes and you said, here you go, good luck, have a nice day. We'll be sitting around to make sure you don't mark anything up or take it away. Now they need to be actually organized to facilitate inspection. What does that mean? Your meeting minutes all go together. Your notices and agendas go together. All of your contracts go together. So you need to organize them. There's not a specific way that the statute requires you organize these records. My suggestion is organize them in the way that they're listed right here. That might make it easier for you. If the official records are lost, destroyed, or otherwise unavailable, there is an obligation to search for them and obtain and recover them if reasonably possible. It used to be if you don't have the record, you don't have it. You can't produce it. Logical. Now you have to go out and search for the record if you have reason to believe that it previously existed and you no longer have it. Okay, so bottom line, scan it all in, put it online, and don't have to deal with these requirements. All you would have to deal with at that point is adding new records as they're created and keeping them organized in this way. Now, an owner has a right to inspect and copy all of the records with exceptions. Okay, there are documents that are exempt from inspection that we'll get into in a minute. But after you receive a written request, now what is written, my opinion, again, an email is good enough here. Whereas the HOA statute requires that it be sent by certified mail, return receipt requested. The condo statute only says it needs to be in writing. So it's not just verbal. You need to provide within 10 business days after receiving the request an offer to come in and inspect the records within 45 miles of the condo or within the same county. Renters do have a right to inspect and copy only the governing documents and inspection reports. Members and their authorized representatives, which is a change from previous law, which was either or. Now it's the member and their authorized representative that can come in and physically inspect. And the association can comply with the inspection by either producing the records physically for inspection or on a computer, or offering the option of saying, here you go, they're available digitally, have a nice day. Or allowing them to be reviewed in electronic format on a computer screen and printed upon request. So keep in mind, this is one of about 8 policies that I think every community should have in Florida, is how you're going to deal with records inspection requests. That's what we're talking about here. Again, 10 business days to produce the records. I don't care that you need to redact them. Unfortunately, the legislature doesn't either. Okay. The right to inspect the records includes the right to make or obtain copies at reasonable expense. The association needs to allow the member to use a portable device, in other words, a scanner or whatever it is, free of charge to make their own copies in lieu of the association providing a copy. And the association needs to maintain an adequate number of copies of the governing documents. What an adequate number of copies is, I have no idea. And by the way, it's not just the governing documents, it's everything listed here. So what is an adequate number of copies? I don't know. Basically enough that you can email out, is my opinion, so that you can produce these records and just say, that's all available on our website. We can give you login credentials if you don't already have them. Now, there's a new requirement effective July 1st of this year to actually maintain and create a checklist of records. This is something that we're doing for our clients as a general, here you go, use this. And, it basically says, here's the categories of records we did produce, the categories of records we didn't produce. The association needs to maintain this for 7 years. Now, it's not clear under the statute whether the checklist means every single document that was or was not produced, meaning you're keeping an actual list, or if just the categories are enough. My opinion is the fact that there is a requirement to maintain the checklist for 7 years means, pardon me, that there's some risk in just presuming that a list of categories is going to cut it. But that is what we're preparing for clients. It's up to them whether they choose to go ahead and include the individualized listing of records in that spreadsheet or whatever it might be. An association delivering a checklist pursuant to this requirement creates a rebuttable presumption that you've complied with that requirement. So if you say we provided all this, we didn't provide this other stuff, presumably then you've complied once you have that checklist. Now you need to deliver that checklist to the owner when they do the inspection. Official records rules. Again, you can adopt reasonable rules. This is the policy that I mentioned a moment ago, governing the frequency. That can be no less than once a month for 8 hours. Time, location, notice, and manner of records inspection and copying. The association can't require an owner, even if you have a written policy, to show a purpose or reason for the inspection. They have an absolute right to inspect the records unless they're exempt from production. So here's the list of records that are not accessible. The records protected by attorney-client privilege or work product privilege related to litigation or any adversarial administrative proceedings. To put that in plain English, if you're consulting your attorney on potential disputes, that is not something that's going to go in the records that are accessible to review by the members. And that's, again, what's not going to go in the member portal either as a result. Information obtained in connection with the approval of a lease, sale, or other transfer of a unit, that's usually going to be like credit checks, background checks, things of that nature. Personnel records of the association or management company employees, although that doesn't mean that you're not going to give the written contract with an employee of the association or with the management company, or budgetary or financial records indicating compensation. It's, well, we reprimanded this person, or this is the insurance they get, things of that nature. This is, the payroll. You get the overall, here's what it cost us in the budget to pay them throughout the year, but nothing else. You're not going to disclose medical records of unit owners. Usually you're going to get that in connection with either a disability related request or in connection with a personal injury case, if you're going to have that at all. The electronic security measures used by the association to safeguard data, including passwords, because you don't want people to be able to access everything and maybe manipulate it. And same thing with the next one, software and operating systems used which allow manipulation of data, even if the owner owns the same software. So you're not giving them access or your file for QuickBooks. You're giving them a printout from QuickBooks that has the same data in it. In other words, you can't mess with our data and change the association records. The affirmative acknowledgments that Kerstin will talk about later, and then personal identifying information of the unit owner other than the unit number, the address, the unit owner's name, their phone number, unless they say that they don't want to give that out, and any address, email address, or fax number provided for association notice requirements. The association can print and distribute a directory containing that information. The association is not liable, again, for inadvertent disclosure of that personal information if it's included in an official record of the association and voluntarily provided by the owner and not requested by the association. So that's a lot of tiers to hit to not be responsible for that inadvertent disclosure. Again, you can consent to disclosing any of these records if they pertain to you. That doesn't mean the association has to produce it. The association needs to ensure the records are not accessible, that are not supposed to be posted. We talked about this earlier. We talked about inadvertent disclosure, and the association is not responsible for the use or misuse of information provided to a member or their authorized representative in compliance with the Condo Act unless the association has a specific duty not to disclose that information. So what we're saying here is if someone gets a whole list of email addresses that are used for association notices and sends an email blast that is inappropriate, the association is not responsible for having given out that information in a way to contact the members. Attorney-client privilege. The most important thing to understand is that this keeps others from knowing your litigation strategy and the advice that you've gotten that might say you shouldn't do this. Okay. Now, it's only pertaining to the work product of your attorney and issues involving potential or ongoing litigation. What you need to understand is that it is not any individual director's right to disclose that privileged information. It's not the attorney's right to disclose that information. It's not the manager's right to disclose that information. It is only the right of the board as a whole to actually vote and say, yes, we want this disclosed, or yes, we're okay with it being disclosed. But no one other than the board can waive that attorney-client privilege. It's not just an individual director. And by the way, individual directors who do disclose that information could potentially be breaching their fiduciary responsibility and be sued personally for that disclosure. Failure to provide access to the records within the 10 business days provided creates what's called a rebuttable presumption that the association intentionally failed to produce the records in time. What does that mean? The owner is entitled to what I call the $500 gift. Okay, a unit owner denied access to records, and that's again intentionally, is entitled to the actual damages. I've never seen damages beyond the minimum of $50 per calendar day, but you never know what someone might come up with for the willful failure to comply. The minimum damages, again, $50 per calendar day, up to 10 days, starting on the 11th business day after the written request to inspect the records was received. What does this mean? Make sure that you provide the records for inspection and copying within the 10 business days to avoid that rebuttable presumption. Now, I said the word rebuttable. I didn't say that there is an automatic presumption that cannot be battled against. If there was a hurricane going on and that's why you didn't respond within 10 business days, okay, that might be an excuse to rebut the presumption. But what this does is shift the burden to the association to prove that this was not intentional, whereas normally it's the owner's burden to prove that it was intentional. The failure to permit an inspection entitles that person to attorney's fees and costs as well if they sue the association. A director or manager who willingly, knowingly, and repeatedly, meaning 2 or more violations in a 12-month period, fails to provide access to these records is now committing a crime as of July 1st of 2024 and must be removed from office. Refusal to allow inspection or copying accessible to unit owners within the time periods required by law in furtherance of a crime is in and of itself a crime. So again, we've got this criminalization of bad intent because of 1% or less of community associations that are committing this wrongdoing. And the legislature just reacts to it because their constituents ask them to, without considering the fact that that might lead some people to say, I'm not willing to serve on the board. But I digress. Other official records offenses, anyone that knowing or willingly defaces, destroys, or otherwise modifies accounting records commits a first-degree misdemeanor. Anyone who knowingly and willingly refuses to release or produce records to escape detention, arrest, trial, or punishment. In other words, I'm hiding a crime. That is a third-degree felony, as we mentioned earlier, and destroying official records in furtherance of a crime is in and of itself a crime. After you come off the board, if you have any records or property of the association in your possession, that needs to go back to the association, whether that's the secretary, the manager, whoever, within 5 calendar days after the election. So this is where we tend to have problems is, oh, well, John was maintaining the records and he didn't give me the boxes that he was keeping them in. Okay, well, stop keeping them in boxes, scan it in and make sure it's on the website. But bottom line, this is where we come up with issues. An outgoing board or committee member who willfully and knowingly fails to relinquish this records and property is subject to civil penalties imposed by the state government. So bottom line, if you're off the board, make sure you're not holding on to any records for no reason. Topic 3. All right, so we're going to stop here. I'm going to stop sharing and I'm going to take a breath and we're going to take some Q&A.
That would be Alan. I don't know how you do it without a quick break. That's fantastic. Folks,
Not well. That's how.
before we head to Kirsten to do parts 3 and 4, Alan is going to look over some of the questions in there, answer a few of them. You're not required to sit here for the Q&A. Now is the time. You have a few minutes if you need a quick bio break or want to go get a drink of water or go take care of something. I, in fact, have Uber Eats on the way with my food right now. I see them out there. So, Alan, take a look at the some of the Q&A and have at it.
All right, enjoy your different kind of bio break. So I'm going to go through the ones that pertain to my subject matter. I'll click that I've answered live so that Kirsten has the other ones that were asked that might pertain to her stuff, and all the other stuff that we didn't cover pending for her when she gets started on her own Q&A. But David asked, can you tell us what is your most perfect definition of a condominium? The one that's in the statute is really all I've got. It is a you can have residential or corporate or commercial, but generally, if you're going by the statutory definition, it's a residential building that is separated into units, and it is a real estate structure where you are basically regulating the air and cutting off the space within a building or buildings, and you have to pay assessments. That's about all I've got. There's really no great definition, but again, if you look at Chapter 718, you'll find the statutory definition, and this is one of those times that the legislature actually does it better than me.
Before Alan gets to the next question, folks, please do not inundate the Q&A with, hey, am I here? Can you see me? Leave the Q&A just for questions pertinent to the topics covered today. If you can see the Q&A, if you can type in the Q&A, you are logged in properly. Back to you.
And by the way, the answer to can we see you is absolutely not, because this is how a webinar works on Zoom. If you post the report on the website, does that allow management to avoid sending the report by mail to each owner? I presume this pertains to the milestone inspection report and structural integrity reserve study. As to the structural integrity reserve study, yes, posting it on the website and giving notice that it's accessible on the website is sufficient. Just posting it is not sufficient for either. The milestone inspection report, you need to at least send the summary out, in my opinion, although I think that there's debate among attorneys as to whether the statute actually requires that or allows you to do the same thing that I just described for the CEUs. Let's see. Does the management company have fiduciary duties to the condo? That's really more Kirsten, Danilo, but I'll just go ahead and answer because it's quick. Yes. So we have to be fully funded by December 31st, 2024, Anthony asks. And the answer, in short, is yes. You need to fully fund your reserves, but if your budget is going to be adopted after December 31st, 2024. Before then, technically, there's an argument that you might not need to fully fund your structural integrity reserves. You already had an argument, you already had a requirement to fully fund your regular reserves that were previously statutorily defined. The only difference is that any budget that's adopted after this date, you cannot waive, reduce, or use CERS reserves for any other purpose. And Anthony clarifies the building's 50 years old, still the same answer. Is CERS report required to be submitted to DBPR? It is. I thought it was just notify that it's completed, but the online submission form tells you to upload the report. Joan asked this question, and my answer is honestly, I don't think you have any obligation to give them the actual report, although they have put something on their website saying that it can be submitted. I'm not aware of any statute that specifies that that report in and of itself must be produced to the DBPR. But, if you choose to produce it just to avoid risk because they're asking for it, that's the board's prerogative. I would suggest you get a written opinion of counsel as to whether that's required or not, so that worst case scenario, at least you've relied on advice of counsel if someone tries to raise one of those breach of fiduciary duty claims against you. Patricia asks, please clarify, are condos less than 3 stories not required to have a structural integrity inspection? Are they exempt from the fully funded reserve requirement? There is no CERS requirement or milestone inspection requirement for a building that is less than 3 stories. Again, as I said, I think 5 times during the explanation, there is only a requirement to do this stuff for buildings that are 5 stories or greater. Now, as to do we need to fully fund the reserves? it's hard to fully fund a reserve that you don't have an obligation to determine what that reserve amount would be. So my opinion is you probably don't need to fully fund those structural integrity reserves, although it may still be a good idea to do so. That's another one I'd say, get an opinion from your attorney in writing. So you can, John asks, so you can pool within the CEUs and you can pool with non-CEUs, but you can't move CEUs money to non-CEUs and vice versa. You can move non-CEUs money into CEUs with a member vote is the more accurate answer to that. Also, you can't move non-CEUs to operating budget. Again, member vote for that one. But you can move operating funds to either non-CEUs or CEUs, correct. Moving on to the next one, Kelsey asks, is the developer required CEUs new, or is that something that would have been provided 8 to 10 years ago? CEUs didn't exist until 2022, so 8 to 10 years ago, there's absolutely no reason your developer would have done that. Let's see. Waiving audits is Kerstin. Did you say an officer on the board does not vote? I said that an officer does not vote as a position. A person who is on the board and is a director votes as a director, but does not vote as an officer. What's the difference between a director and board member? There is none. They're both the same thing. John asks, how long does the board have to fill a vacancy due to resignation? As long as you need, unless you are ending up in receivership. I'm going to let Kerstin deal with the next vacancy question by the same person. David, how much liability insurance do we need? Kerstin, I'll let you deal with that. If a treasurer provides a summary page of what they're discussing, does the summary page become official record? Technically, there is an argument in either direction. If they are giving a summary, but there is documentation to support everything they're discussing, then you don't need that summary, but you can put it in the official records. If there is nothing else and it's just a discussion, I would argue that if that is used at a board meeting or is used to discuss what the treasurer is talking about, it probably should be included in your official records. Is late payment information accessible to all members? Yes. There are fair debt laws, David, that would prohibit certain people from providing that information, but you are able to access all owners' ledgers as official records of the association without having to give a reason that you're asking for it. Bartolome asked, the past board borrows money from the reserves to be used with the approval of homeowners to use for other purpose. Is there a time to repay the money back to the reserve? Basically, you have to add to your reserves in the following year to end up where you are back on track to have somewhat full funding of that reserve account, even though you used the funds last year. I'll skip some of these. I don't know what they do not refers to. Does the meeting between the board and lawyer need to be posted? The answer is yes, but I'll let Kerstin elaborate on that later. I already explained officers don't vote. Does the intent form need to be signed or can it be sent by email? It needs to be signed, but it can be sent by email, in my opinion, if the association accepts them that way. We already answered this twice. David asks, roof lives are now only 15 years. Why? Insurance companies will not go beyond 15 years because insurance companies get away with a lot that they shouldn't in Florida is really the only answer I have. There are laws that were recently passed, and I would suggest that you speak with whoever is going to potentially work on your roof to answer those questions directly. But there are laws that you can talk about with your contractor or your attorney that might kind of let that roof last a lot longer. And frankly, as long as it is warranted is probably how long your insurance carrier should be giving you. What are the exemptions for milestone inspections? Same as CEUs. Again, if you are less than 2 stories, you don't need, less than 3 stories, you don't need either one, and that is determined by the Florida Building Code. If you have a 1, 2, 3, or 4 family residence that is 2 stories or less, or 3 stories or less, you don't need one. I don't know what other exemptions we're looking for here, but feel free to email me if you think there might be something else. What happens if none of the current board file for candidacy? 1 or 2 members do file, but not enough votes are returned to validate the election. How do you move forward? If there are not enough votes to move forward and have an election, then you have the board roll over. Everyone that was on before stays on, whether they filled out the candidate information sheet or not, because you didn't have an election. How do you handle all condo records prior to 3 years ago being completely lost forever as it relates to retention requirements? Well, I handle it by saying we don't have them and we've done everything we can to try and get them back. If they were destroyed in a fire or something like that, what I would suggest is in your current records, have an affidavit of someone who knows what happened to them that states exactly what happened to them and is accessible in lieu of producing the records so that you can explain why you don't have them. How does and this is Charles again, how does the current building integrity requirements compare or contrast to the previous 40-year building structure requirement? Fairly simple and fairly similar, frankly. But there are a little bit more that's required now because of the structural integrity reserves that are now required to be set aside versus just having the repairs done. The 40-year requirements are more comparable to the milestone inspection report. And that's really what I'll say that's why, because they're so similar, that is why the legislature has said, if you already had one of those done and it meets the requirements of the milestone inspection report, just use that and go 10 years from the date of that report. If we have 35 residents, how many directors are required? Probably 5, but look at your bylaws. Reserves interest earned must stay in CERS reserves. Yes. Do the monies to the reserve have to be funded equally? They have to be funded based on what's in your structural integrity reserve study, not just an equal amount for each category. Can a unit owner be required to use email? No. I wish they were, and I wish the legislature would push that, but as of now, no, they need to opt into receiving notices via email. Our condos are 2 stories. However, it does have a basement and a portion. Does this trigger the 3 stories or more? I am very happy for you that you have a basement. I wish I had one of those in my home, but the bottom line, you're going to need to consult with someone who is more well-versed in construction than I am. It depends what the Florida Building Code would say about that particular basement and whether that meets the definition of a story under the Florida Building Code. Let's see, requested a roster and the property manager refused to allow that. Isn't that my main job? You should be receiving them as a member of the association. But the fact that you're a newly elected director and secretary, chances are that job that you're talking about was transferred to the manager via the management contract. So it might not be your responsibility, even though under the bylaws it normally would be. Let's see. It looks like we still have 7 minutes. I'm going to keep going and try and clear out as many as I can, guys. What if a director's been on the board at least 8 years, but stated they were on for 4 in order to be on the board? I have no idea what that means, Andre. Feel free to call me later because if they've been on the board 8 years, but stated that they were on for 4 in order to be on the board, they're on the board for 8 years. So, as of 2026, they will need to step down temporarily if they want to stay, unless there's no one else willing to serve. Is it appropriate for a board member to answer the phone? Okay, Kerstin, that one's you. Can a milestone inspection report or CERS be modified or changed after initial filing? Only by the company or individuals that actually prepared the report. You cannot just unilaterally decide, I'm going to go ahead and change this because I disagree. It needs to be someone who actually wrote the report. Let's see. Retention of complete records. What's the responsibility when there's a transition of new directors? The association has the exact same responsibilities. And unfortunately, it is not infrequent that we need to send a demand to the prior manager, not with GRS, but with other management companies who will remain nameless, that I have to send a demand saying, hey, the association cannot operate because you haven't given them, pardon me, all of the records they need in order to continue operating. Now, the statute was changed this year, and Kerstin will get into this later, but they have 20 days to produce all of the records and property that the prior manager has. If they don't do it within that amount of time, the association can send a demand, file a claim, and there are penalties that I'm sure Kerstin will talk about later for not complying with those requirements. And that is a management obligation and a board obligation. I talked about the within 5 days after the new directors are elected and the person comes off the board. Kerstin will address the management obligations, and we'll move on from there. What records are now classified as hazardous material after Hurricane Milton? What do we do? If they're hazardous material, then hopefully someone has the capability to scan them in despite their being hazardous. I'm guessing that's mold issues. And again, if you're not able to, then I would get an affidavit, not from a director, but directly from the company who qualified them as hazardous materials, saying that you cannot have them and we have no way of safely scanning them in. Most of those companies work with a vendor that will do the scanning in a clean room, but I can't really give you too much advice on that one because it's not something I do personally. Term limits, 8 years or 8 terms, 8 years. So it doesn't matter how long your term is. If you have 3-year terms, you're only allowed to serve part of the third one. I mentioned 5 members of a board. We have 7. Is that okay? How about 9? Betty Ann, depends on what your bylaws say. You can have more. You just can't have less than 5 if you're the right size of condo. Board members said they took an exam for being a property manager at another building and they don't need to take this webinar. Is that correct? Bernardo, they don't know what they're talking about. And I hope that you're making sure they understand that if they don't take this class within 90 days after being elected, they will be off the board. Ben, is a board member required to keep any emails or personal records? Personal records, no. But when it comes to personal records that impact the operation and business of the association, yes. Again, emails, there's disagreement among attorneys, including those as qualified as we are, as to whether that's an official record or not. My opinion is be overly inclusive, even if that means you get in trouble because the association did something wrong. I'd rather have you get in trouble because you had the record and it was proven that you were wrong than you get in trouble because it looks like you were hiding the ball. At least that's my personal opinion. Mary Carmen, a board member that's been a member for a few years, do they need this course? Until when is their certificate valid? Kerstin will address when their certificate is valid. My answer is yes, they need to take this course. Joanne, how long do we need to keep monthly financial statements? That one I believe is now indefinitely. If not, it's 7 years. And by the way, I didn't mention it, but another of the 8 or so policies that I think everyone should have. This one is statutorily required, although it's not in the documents here, is a records retention policy saying how and when you're going to destroy your records, how and where they will be maintained, etc. So everyone should have one of those. Moving on. Oof, we're coming close. I got 3 minutes left. I'm going to give you the time, Kirsten, I promise. We're approving our budget before December 31st, 2024, but our fiscal year is January 25th. Do we need to prorate that January month for our fiscal year 2027? If you are adopting a budget before December 31st, regardless of when the actual fiscal year starts, then those structural integrity reserves need to be included and fully funded. Bartolome asked, milestone inspection, 50 years. We contract in July 2024. The engineering company hasn't showed up for the inspection. How much time do we have before the city actually finds us? I don't know what city you're in, so I can't answer that. But hopefully you have explained to the city. Oh, that's regarding, I don't know if Diego was asking that question or somebody else, but hopefully you're explaining to the city and showing them a copy of the contract and looking into alternative contractors and sending these people a breach of contract notice saying it's been months, you haven't come out, when will you be here? And if you don't come out, then just understand that we will be using another vendor and not paying you a dime. Insurance companies require roof to be 15 years old or less. Why does the CEUs use a 20-year useful life? Because that's the actual useful life of the roof, and the insurance company is screwing you. Leo asks, so funds in a reserve can be moved to an operating account with a vote of the board and it being approved? Absolutely not. That is the opposite of what I said, Leo. The vote needs to be by the members and not just by the board. It needs to be a majority of all voting interest in the condominium, and it can only be moved up until the end of this year for the non-structural integrity reserves. Let's see. Oops, cancel that and answer that. Former president who failed to properly maintain records is now conducting a records request. Best way to handle this, respond that we don't have the records because you're a jerk. Do you have to have a 40-year inspection in a 2-story building? I don't know if you're asking about the milestone inspection or a separate municipal requirement. You do not have to have that for a milestone inspection or a structural integrity or reserve study, Ruth. But I don't know what municipality you're in, so I can't answer whether that separate 40-year requirement is going to apply because the milestone inspection is pertaining to a 30-year requirement. Can we have a partial reserve vote if we approve the budget before December 31st, 2024? If so, do we have to prorate? I answered that one already, so I guess it was just asked twice because I hadn't answered it yet. Our CAM is emailing owners without a release. I don't know what the release is, so that doesn't really help me answer. Yeah, I have no time left, so I'm sorry, I'm not going to be able to answer that. Are there term limits? 8 years as of the July 1st, 2026, Lewis. But also look in your bylaws for any other term limits. Banning owners is Kerstin. Do you have an email contact to submit the CEUs to City of Miami Beach? I do not personally. It's probably a form online. Ruth asks about Fort Lauderdale. So again, when we were talking about the 40-year requirement, that's going to be your attorney in particular that you need to contact. If the officer or board doesn't have this certification, how would you do this? Betty Ann, I presume you mean how do you pull them off? And you just tell them there is a statute that says you're off the board until you complete this requirement. K-Bender Rembom will probably be teaching another class next month. Have a nice month. And Kerstin, I went over by 1 minute. I'm so sorry. It won't happen again. All of the appreciation to all of you. Thank you very much. I'm going to stick around. I will still be available, but I'm going to give it all the way to Kerstin now.
Thank you, Alan.
Nice, Alan. Good job. All right, go drink some water. All right, everyone. So we're on topic 3, covering levying of fines and financial literacy and transparency. And again, I'm sure Alan mentioned this, but these are the topics that we are required to teach you straight from the division. All right, transfer fee. So transfer fee refers to also known as an application fee, and that will apply in connection with a transfer of either title in the unit through sale or any other type of conveyances, or via a lease, right? So what the statute says is that you cannot charge a transfer or application fee unless you have specific authority in your governing documents, which are either the declaration, the articles, or bylaws. So you have to have express language authorizing you to charge this fee. And this fee is charged in connection typically with a background check that is run on the applicant that's applying either to buy a unit or to lease a unit. Okay, you also have to have authority in your declaration to approve and disapprove purchasers and tenants. Okay, so if you have this as a policy as opposed to a specific authority in your declaration, this will not be enforceable. This is not going to fly. This is going to be subject to legal challenge. Okay, so make sure that your authority to approve, disapprove sales, leases, and then the authority to charge a transfer fee in connection with those applications is in your governing documents. Now, if you do have that authority, the fee cannot exceed $150 per applicant, bearing in mind that husband and wife and then parent-dependent children are considered one applicant. Okay. Now, if you have the ability to approve leases and then lease renewals as well, then if there is an application for a lease renewal, you cannot charge another transfer fee if you're going to have the same tenants or the same tenants are applying. Now, security deposit. The statute also addresses security deposit and basically says also if you are authorized in your declaration or bylaws, then the association can charge a prospective tenant a security deposit that does not exceed 1 month's rent, whatever that prevailing rent is in your community, and it'll have to be held in escrow. Okay. Typically, we do not recommend that you, include any specific rent amount in your declaration. Same with the application fee. If you're amending your documents, don't recommend that you actually identify the amount. Rather, give yourself a little bit of flexibility and have the amendment read, the board is authorized to charge a security deposit or a transfer fee in the highest amount allowed by law, as amended from time to time. That way, if the statute changes, well, that amount in your declaration will change automatically without having to amend it in the future. A note with a security deposit, it can only be used to cover any damage to the condominium or association property that is caused by the tenant. It is not really intended for you to put in association account and apply towards any delinquent assessments of the owner or any fines or any other unpaid monetary obligation, okay? It's supposed to only cover damage to common elements, association property. All right, estoppel certificates. Now, when you have an owner in your building that is looking to sell their unit, the association or management company will often receive what is known as a request for estoppel information, right? So what the estoppel certificate is, and I'll specifically on the next slide go through what it's required to say. But essentially, on the estoppel certificate, you'll identify certain information that the buyer needs to be aware of, okay, before closing, whether it's outstanding violations or any unpaid assessments, so that those items are addressed before closing. Now, if you receive a request for estoppel information, then you have an obligation to respond within 10 business days, okay? Now, the association must designate on its website a person or an entity with a street or email address that's going to receive these estoppel requests. The estoppel certificate has to be completed either by a board member or an authorized agent or representative, which can include your property manager, even your attorney. The estoppel certificate has to be provided by hand delivery, regular mail, or email. And the certificate has to be signed by an officer or an authorized agent of the association. Now, the general information that you will identify on the certificate, and by the way, this is all already laid out in the statute, so you don't have to sort of recreate this wheel, but you'll include, the name of the owner, the property address, the parking space associated with the unit, attorney's name if the association is represented, name of the requesting party. And then there's a section that identifies basically the assessment information, okay? What your regular periodic assessments are, the date that the next regular periodic assessment will be due, the date that it's paid through. You'll you'll itemize all assessments, special assessments, and then any other monies that are owed by the selling owner to the association. So included in that would be any fines, certainly attorney's fees, any interest, any late any administrative late fees. If, for example, the owner has damaged condominium association property and the association incurred an expense in addressing that damage, you would also reflect that on the account ledger as well as on the estoppel certificate. All right, and then other information, for example, if you are authorized to collect a transfer fee, you would include that in the certificate. If there are any open violations, that is the time for you to identify it on the certificate, because if you don't disclose any open violations, then potentially once the closing occurs, the association could be in a position where the new owner could raise the defenses of waiver, right? You sat too long, you didn't address it, you didn't disclose the violation on the estoppel, and now you've waived your ability to enforce this against me. So if there's any open violations, definitely reflect those on your estoppel request. If the association is authorized to approve and disapprove sales, you'll have to identify that, as well as if the association has a right of first refusal relative to sales and transfers. Now, the statute allows the association to charge certain fees in responding to an estoppel request. So the general fee that the association can charge is $299 for responding to an estoppel request. And that's if there's no delinquent amounts owed to the association by that unit that is the subject of the request. Now, if the unit happens to be delinquent, then in addition to that $299 fee, the association can charge a fee up to $179. Now, if the requesting party has made a request for an expedited response to the estoppel, then you can also charge an additional $119. Now, if the association fails to deliver the estoppel certificate within the 10 business days of receipt of the request, then the association will not be able to charge this fee. Okay. Now, the statute also provides a table, a fee schedule of fees that the association can charge in response to multiple requests for estoppel. So if a estoppel certificate is requested for multiple properties owned by an owner, these are basically the fees that you can charge. So you can see if the owner owns more than 25 if the owner owns 25 or fewer parcels, you can charge $896 and so forth and so on. Now, these fees are subject to change. They will be adjusted every 5 years in an amount that is equal to the total of the annual increase for the 5-year period in accordance with the Consumer Price Index. And the DBPR, the Department of Business and Professional Regulations, is the regulating body that will essentially adjust these estoppel fees. All right, and then they will publish them. Okay, so this is not something that the association does. This is something that the DBPR will automatically do every 5 years. Now, if your response to the estoppel request, if the estoppel certificate is delivered by hand delivery or by email, then the information that's reflected in that certificate is good for 30 days. Okay. If the certificate is delivered by mail, then that information on their certificate is good for 35 days. Okay. The association, keep in mind, cannot charge for an amended estoppel certificate. So if there's something that needs to be amended on that certificate that you just provided, you can't charge an additional fee. You can, however, charge for a new estoppel certificate, even if it's regarding the same transaction, if it is issued after the previous estoppel certificate expired. Okay. So sometimes closings are postponed, sometimes up to multiple months. If you receive another request for estoppel and you have to prepare a new certificate, you can charge an additional fee for that. Now, sometimes you might get an owner or even the lender that is looking to provide a loan to the owner for purchase of the unit. They might be looking or requests additional information from the association. Well, the statute provides that the association and its authorized agent can charge a reasonable fee to respond to those inquiries from a prospective purchaser or lien holder, a lender that's looking to make the loan. And you can charge essentially a fee that does not exceed $150 for preparation of that response, plus any reasonable cost of photocopying, as well as attorney's fees incurred in connection with the response. So if the association needs to, seek legal guidance on the response, the association can recover the attorney's fees incurred from the prospective buyer or the lien holder. Now, the statute does provide that the association and the agent, they're not liable for providing the information requested in good faith as long as you include this statement in your response. And the statement is at the end of the slide, essentially, the responses herein are made in good faith and to the best of my ability as to their accuracy. So again, if you are responding to an inquiry made by a prospective purchaser or the lender, make sure that the association or certainly the legal counsel includes this disclosure in the response. Now, other purchase and sale documents, well, there is the condominium question and answer sheet that must be provided to prospective purchasers. And the question and answer sheet is a form that the board can obtain from the division. And it's a single page that has a number of questions. essentially, can you rent in your community? What are your restrictions? And some other questions. So you got to make sure that you have responses to those questions, and you keep that Q&A sheet as part of your official records, because it has to be provided to prospective purchasers. Now, obviously, every year you might need to take a peek at your Q&A to make sure it's the information reflected on it is still good, and if not, you'll need to update it annually. For residential sales transactions, the seller's duty to provide buyer notice of all hidden defects. That's obviously on the selling owner. That's not an association obligation. Other disclosure information documents that the selling owner has to provide at the seller's expense include, well, they have to provide a copy of the declaration, the articles, bylaws, rules, as well as the frequently asked question and answer sheet. And the prospective purchaser is also entitled to receive what is known as a governance form. And this form, again, basically summarizes the governance of the condominium association. And on this slide, you will see this is the information that the governance form must address. Basically outline the role of the board's responsibilities to provide advance notice, the right of owners to attend and speak at board and membership meetings, the responsibility of the board as it relates to the maintenance of condominium property. The governance form also has to include information about the owner's right to inspect and copy association records, remedies available to the owner with respect to board actions, the voting rights of owners, as well as the rights and obligations of the board in enforcement of rules and covenants. All right. Moving on, the next topic we're going to talk about is suspension of use rights, voting rights, and fining. Okay. So what we're going to talk about now is suspension and fining for covenant violations. Okay. In the following slides, we'll talk about suspension of use rights when an owner is delinquent, but these slides pertain only to suspension of use rights and fining when an owner or the owner's tenant, occupant, guest, or invitee have violated the governing document or association rules. So the authority to fine or suspend use rights for covenant and rule infractions does not have to be specifically provided in your governing documents. That is authority that the statute already gives to a condominium association. Now, the fundamental process of fining and suspending for covenant and rule violations has not changed in the statute. It's virtually the same. And again, it's a two-step process. It is the first part, the board adopts the fine or the suspension. And then the second part, which is what's on the slide, is that you cannot impose the fine or suspend use rights unless the violating owner has been notified of a committee hearing, at which committee will meet and basically vote on whether to confirm or deny the fine. Okay, that committee hearing is absolutely crucial in the step of fining and suspending for rule and covenant infractions. Okay, when you mail out that notice of that committee hearing, it's very important that you provide an owner at least 14-day notice of that committee hearing. Okay, otherwise the owner could have a basis to legally challenge the suspension or the fine. Now, the committee, the hearing has to take place before an impartial committee of at least 3 individuals. And the role of the committee is really not to negotiate the fine or negotiate the suspension. The sole role of the committee is really to determine whether or not to impose or ratify this imposition of fine or suspension. So it's essentially a yes or no vote, okay? And if the committee votes against the fine or the suspension, then it cannot be imposed. Now, the committee has to consist of at least 3 members of the association who are not officers, directors, or employees of the association, or the spouse, parent, child, or sibling of the officer, director, or employee. The fine also cannot exceed $100 per violation. With each day that that fine continues, it tacks on that $100, and the maximum that you can impose on a fine for that particular violation is $1,000 in the aggregate. That's the max that the statute allows. Now, unlike with homeowners associations, the condominium statute specifically says that this fine cannot become a lien against the unit. Okay, which means that if the owner does not pay the fine, presuming you went through the whole fining process correctly, and the owner does not voluntarily pay the fine, you cannot then collect it as a lien. Okay, so you cannot go through the collection foreclosure process to recover this fine. The way you would collect it is essentially the fine would go on the owner's account ledger. Okay. Now, for $1,000, unlikely that the board is going to pursue litigation, right? I mean, the cost of filing a complaint in small claims court is $500, right? So that's half of your fine. So unlikely that the association would pursue a court action to recover it. So the more likely outcome is that you're just going to put this fine on the owner's account ledger, and hopefully when the owner sells the unit, you will reflect that fine on the estoppel certificate and then try to recover it at closing. Okay. If the committee does ratify the imposition of the fine, then the fine is due 5 days after the date of the committee meeting, which the fine was approved. All right, so switching gears, now we're going to talk about suspensions for monetary obligations. So if an owner is delinquent to the association on any monetary obligation for more than 90 days, the association also has the ability to suspend use rights to common elements and common facilities, certain common elements, and we'll talk about which common elements suspension does not apply in a minute. But essentially, if you are suspending use rights due to the owner's delinquency, that suspension only requires a 48-hour board meeting notice, okay? So you don't need the board action and then the committee hearing. The board simply posts notice of that meeting 48 hours prior to the meeting with an agenda item, suspension of use rights of unit, 100 due to delinquency, or words to that effect. The suspension then, if it is approved by the board, it'll be effective until the monetary obligation is paid in full. And the monetary obligation can be not only assessments, regular or special assessments, obviously attorney's fees, interest, administrative late fees, and it could also even include a fine. So if the owner was fined, the owner didn't pay the fine, well, guess what? Now that fine is delinquent, a delinquent monetary obligation. So now the board can also suspend use rights if the delinquency exceeds 90 days. The suspension of use rights applies not only to the owner, but also to the owner's tenants, guests, or invitees when appropriate, if they're the violators. Now, the suspension typically applies to common facilities. And typically those facilities that the association has the ability to regulate access. So for example, your clubhouse, your pool, maybe your tennis courts, a library, and these types of amenities. And really this would only be a viable option if you have the ability to control access, right? So if you can deactivate a key fob, obviously this might be a useful remedy for you. If you don't have the ability to control access, then this might not be a good enforcement tool. There are other remedies that you can pursue, and you should seek advice from your legal counsel. But the suspension absolutely would not apply to limited common elements that are intended to be used only by that unit. So for example, a balcony, a limited common element balcony to the unit, you would not be able to suspend the owner's ability to go onto his balcony or his patio. It would not apply to common elements needed to access the unit. So you couldn't suspend the right of an owner to use the hallway to get to the unit. Would not apply to utility services, parking spaces, or elevators. So you cannot prevent an owner from using an elevator to get to his or her unit, or from parking in his or her assigned parking space. Voting suspensions. So in addition to suspending use rights due to an owner's delinquency, the board has the ability to suspend an owner's voting rights if the owner is more than 90 days delinquent in any monetary obligation to the association. So just like with the suspension of use rights for delinquency, suspension of voting right only requires a board meeting, board action. There's no requirement for there to be a committee hearing to ratify that suspension. So all it requires is a 48-hour posted notice. Again, the suspension is effective until the monetary obligation is paid. Not only does the owner need to be delinquent for more than 90 days, but the actual delinquency has to be greater than $1,000. That's if you are suspending voting rights. And then you have to provide the owner with proof of the obligation at least 30 days before you actually take action to suspend the voting rights. Okay. Now, case law came out not long ago in 2020, which essentially suggests that the authority to suspend voting rights has to be specifically in your governing documents, unless you have what is known as Kaufman language. And Kaufman refers to the magic words as amended from time to time that typically follows reference to the condominium statute. So if you have Kaufman language as amended from time to time, that means that the authority to suspend voting rights in the statute would apply to your community. If you didn't have Kaufman language, then the case law suggests that you needed to have an express provision in your document authorizing you to suspend voting rights in order to be able to do so. Okay, so essentially, in an abundance of caution, if you don't have Kaufman language and you want to have the ability to suspend voting rights, then perhaps consider an amendment to your documents to give you that specific authority. Now, what essentially is the result of suspending voting rights? Well, for many communities, this could be potentially a useful tool if the board is trying to pass certain action requiring owner approval. Because when you suspend voting rights, okay, essentially the voting interest that's allocated to the unit cannot be counted towards quorum and cannot be counted towards the votes that you need to approve an action. So for example, in a condominium with 100 units, if you're trying to get certain amendments passed, right, and those amendments require the approval of a majority of the owners, and that's 50% plus one, and let's say you've now suspended properly the voting rights of 10 owners, okay, well, the vote that you would need to get those amendments passed, now it's not a majority of the 100 units, it's a majority of the 90 units, okay? So for many, that could be a useful tool. All right, budgeting, budgets and reserves and financial reporting. All right. So the board has an obligation to prepare an annual budget. So that means every year you have to adopt the budget, which includes estimated revenues, your operating costs, and reserves for the upcoming fiscal year. Your budget also has to disclose the beginning and ending periods for the fiscal year and the total assessments for each unit type. Okay, so this is straight from the statute. You'd be surprised how many boards have budgets, and sometimes budgets prepared by accountants that don't even have the very basic information required by the statute, which is the beginning and ending periods of your fiscal year. Okay, and if an owner files a complaint with a division based on a violation of the statute, and the division finds a violation, well, you potentially are at risk of subjecting the association to monetary penalties, basically a per unit fee. Okay, so very important that your budget has these minimal elements required by the statute. So at a minimum, your budget will likely or should include the following line items. I mean, administrative expenses, management fees, if you've hired a management company to assist with management, certainly all the costs of maintenance and repair. If you have a recreation lease under which you have to pay rent and you're collecting rent from owners, that needs to be on your budget. Obviously, any tax expense, any taxes, your insurance costs, professional expenses. So if you have an accountant that you've retained or you have legal counsel on retainer, definitely identify a line item budget for these professionals. And really any other expense that you feel is necessary in order to properly operate and maintain your condominium and association. And then you'll also have a separate reserve schedule and any fees that are paid to the division. Now, in terms of the budget adoption process, typically fall is the budget adoption season, fall going into December, and then for some into January and February. But the basic process of adopting a budget is the board needs to properly notice a meeting. It's a board meeting. A budget is a board meeting at which the board will adopt the budget. And that meeting has to be noticed by providing owners with a 14-day notice of the meeting along with a copy of the budget. So not only do you have to provide the notice of the meeting with the agenda, and the agenda will typically include, adoption of your 2025 budget, and it could include other agenda items, but that would be a primary agenda. But it also has to enclose a copy of your proposed budget. Now, that notice and copy of the proposed budget could either be hand-delivered, it could be mailed, or it could be electronically transmitted to those owners who have consented to receiving notice electronically. Okay. Owners are obviously entitled to attend the budget meeting. Now, the person who's providing the budget, and it could be your secretary or it could be your property manager, but whoever has mailed out or sent out the notice with the proposed budget has to sign an affidavit evidencing compliance, indicating that they properly and timely sent out the notice with a copy of the proposed budget. Now, remember, you're adopting a proposed budget. Okay, so it is an estimation that's based on the previous year's budget, right? So when you get to your budget meeting and you're reviewing the budget and you're discussing the budget and you find that there are some line items that you might have to tweak, whether increase the budget or decrease the budget for certain line items, you can still adopt that budget at that meeting. You don't need to renotice another budget meeting or resend, a revised budget to the owners. Okay, you can adopt that proposed budget at that meeting. Now, if after that meeting, the board wants to further amend or adopt another budget, then yes, you're gonna have to renotice that meeting and then, send out your notice with the proposed budget for that meeting. Now, effective July 1st of 2021, the statute changed to now require the budget to be adopted at least 14 days prior to the start of the association's fiscal year. So for many associations, your fiscal year runs on a calendar year. So that means that you are required to adopt your budget at least 14 days before December 31st, if you're on a calendar year. Now, the statute does say that if the board fails to timely adopt the annual budget a second time, then that is deemed a minor violation, and then the prior year's budget continues in effect until the new budget is adopted. Why the legislature, adopted the statute with a second time, as opposed to, the first time, who knows? But that is what it currently provides. All right, so we're going to talk about reserves. Alan talked about the CEUs reserve requirements based on the Structural Integrity Reserve Study that applies for condominium associations that operate condominium buildings that are at least 3 stories or higher. That said, the statutory reserve requirements that have been in existence in the statute for years has not gone away. So these reserve requirements that I'm going to talk about apply not only to condominium buildings of less than 3 stories, but it also applies to condominium buildings of 3 stories and higher. So for those associations with 3 stories or higher, you will have 2 sets of reserves. You're going to have your CEUs reserves, and then you will have your regular statutory non-CEUs reserves. So capital expenditure and deferred maintenance, we've provided definitions here. Capital expenditure essentially means any expenditure of funds for the purchase or replacement of an asset whose life is greater than 1 year. And a deferred maintenance means any maintenance or repair that will be performed less frequently than yearly. Now, we've identified here some of typical capital expenditures, deferred maintenance reserves, which include roof replacement, building painting, balcony restoration, seawall replacement, and you could have others. Now, as Alan mentioned, the CEUs requires condominiums of 3 stories and higher to maintain reserves for certain specific items, right? Like roof replacement. But it doesn't necessarily cover everything. And so this is why the regular non-CEUs statutory requirements have not gone away, because you might have a seawall, okay, that might not necessarily fall under CEUs unless your engineer says so. But if it's not a CEUs, then it might be a reserve item that you would need to fund under your regular reserves. So what the statute provides is that these non-CEUs reserves, okay, you have to fund for these 4 basic items: roof replacement, building painting, pavement resurfacing, and then any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. Well, again, the roof replacement and building painting are part of the CEUs, okay, but pavement resurfacing is not. So pavement resurfacing is something that's going to fall under your non-CEUs reserve requirements, as well as any other item that has a deferred maintenance expense or replacement cost of over $10,000 that doesn't necessarily fall under CEUs. Now, how do you compute these reserves? No different than how the CEUs reserves are computed. They're going to be based on the formula based on the remaining useful life of the reserve item and the estimated replacement cost or deferred maintenance expense. Now, down below here, we've identified here exactly what your reserve schedule is going to look like. And really, this is exactly what it's going to be for your CEUs as well. So unless the association maintains pooled account reserves, your reserve schedule is going to be broken down for each reserve account, and it's going to identify the total estimated useful life of the asset, the estimated remaining useful life of the asset, then the estimated replacement cost, and then the estimated fund balance. And if you are, or if you have pooled reserve accounts, okay, then you're going to have a pooled reserve schedule identifying basically the same points above, but for each item within the pool. Now, unlike your CEUs reserves, which cannot be waived or partially funded for budgets adopted after December 31st, for non-CEUs reserves, you're still allowed to give owners the option to either waive or partially fund those reserves. So the default is that you have to fully fund these non-CEUs reserves unless owners vote to either waive or partially fund them. Now, if you want to give the owners that option to waive or partially fund these non-CEUs reserves, well, that's totally within the discretion of the board, right? It's you, the board, that makes a decision whether you want owners to waive or partially fund these reserves. But if you give the owners either option, then the vote that you need to get in order to have these reserves waived or partially funded is a majority of the voting interest. So again, it used to be that you needed to get a vote of the majority of quorum, a majority of those owners who are present at a meeting at which a quorum is established, but that threshold has now been increased. So you do need a vote of the majority of the entire voting interest. If at the meeting you don't get the necessary votes to waive or partially fund reserves, then you have to fully fund reserves. Alternate use of these non-CEUs reserves. Again, unlike CEUs reserves, which can no longer be used for alternate purposes after December 31st, with non-CEUs reserves, you still have the option to potentially use those reserve funds for alternate purposes, for purposes other than for which they were initially reserved, but you do need to get the owner's votes for that. And the vote that you need is also a majority vote of the voting interest. So, for example, if you have a roof replacement project that's coming up and you're a little bit short, hopefully you've been funding reserves for roof replacement, but let's say you're a little short on your roof replacement reserves, but you have been reserving for, for other reserve items. Again, if this is non-CEUs reserves, you have the flexibility to use these non-CEUs reserves allocated for other purposes, provided you get a vote of the majority of the voting interest. Pooling of your non-CEUs reserves. Alan may have already mentioned this. You can pool your CEUs reserves, but you can also pool your non-CEUs reserves. Okay, you just can't pull them together. And again, the benefit of pooling reserves is that if you have a shortfall of reserves designated for any particular item in the pool, well, you have the flexibility to use monies within the pool for any one item that's within the pool. You can't use it for items outside of the pool. And at some point, you're going to have to replenish those funds, and that's a discussion you're going to have with your accountant. If you're going to give owners the option to waive or partially fund non-CERS reserves, then the statute requires that you include this disclosure on any limited proxy or ballot that's given to the owners to vote on. And the disclosure has to be in bold, capitalized letters, and essentially has to say waiving of reserves in whole or in part, or allowing alternative uses of existing reserves may result in a unit owner liability for payment of unanticipated special assessments regarding those items. So make sure that if your management company is putting together a membership meeting notice package for the owners to vote on waiving or partially funding non-CERS reserves, that the limited proxy and ballot includes this disclosure. All right, we're going to switch gears now to financial reports. Now, what the statute provides is that within 90 days after the end of your fiscal year, or annually on the date provided in the bylaws. So if your bylaws have a specific date, you go with that date. Otherwise, it's 90 days after the end of your fiscal year, the association has to prepare and complete a financial report of the preceding year's financial activities. And typically this financial report would be provided by or prepared by your accountant, your CPA. Now, once that report is completed, within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, the association has to mail or hand deliver to each owner a copy of the most recent report and a notice that a copy of the recent report will be mailed or hand delivered at no charge within 5 business days upon receipt of the written request. Now, the and used to read or, so it used to be that you had to provide a copy of the report or notice of its availability and that it would be provided free of charge upon the owner's request, but the statute was changed last year to provide and. It makes no sense, but that's what the statute provides. Now, the association also has to provide an annual report to the division containing the names of all of the financial institutions within which it maintains accounts. And a copy of this report may be obtained from the DBPR. Now, the level of your financial reporting will depend on the total annual revenues of the association. Unless, of course, your bylaws require an audit. So the thresholds here come straight from the statute. So for example, if you're an association with a total annual revenues of $150 or more, but less than $300,000, then all you are required by statute is to prepare compiled financial statements. That is, unless your bylaws specifically require you to prepare an audit regardless of what your annual revenue is. So if that's the case and you have express language in your bylaws requiring an audit, then you have to get an audit done. Okay? Otherwise, an audit is only required under the statute if the total annual revenue of the association is $500,000 or more. Now, the statute does allow an association to reduce the level of financial reporting. So if your bylaws don't require an audit and you're just doing a financial report based on the total annual revenue thresholds that's provided in the statute, let's say you're required to do an audit and you want to do a lesser report. Well, the statute allows you to reduce the level of financial reporting provided you get membership approval for that. The statute was changed last year, or in July, to now say that if owners vote to reduce the level of financial reporting, you cannot do this for consecutive fiscal years. Okay, so just be aware of that. All right, moving on to topic 4. Which is notice and meeting requirements, insurance requirements, and conflict of interest. So we're going to talk about membership meetings first. So you're going to have membership meetings can be one of two types of meetings. It has to be either an annual meeting or it can be a special membership meeting. The annual meeting, at the very least, if nothing else, you will have one membership meeting, which you will call it annual members meeting. And it is at this meeting that you have to conduct your election. So your elections will be done at your annual members meeting. Now, your annual membership meetings must be held at the location provided in the bylaws. And it will be on the date and time that's provided in your bylaws. And some of the older bylaws that we've seen might say something to the effect of, you know, the annual meeting has to be conducted on the third Thursday in December. Okay, if that's what your bylaws provide, then that's when you have to conduct your annual membership meeting. If you have this language, then you might want to consider amending it to give you, the board, a little bit of flexibility in conducting your annual meeting. So you might you might want to propose an amendment that simply says that your annual meeting shall be held on such date, time, and location as determined by the board from time to time. So as long as you have an annual meeting every year, it's up to you, you know, when you want to hold that meeting. If the bylaws are silent on the location, then the meeting has to be held within 45 miles of the condominium property. Now, membership meetings need to be held at a location accessible to physically handicapped persons if it is requested by a physically handicapped person who has a right to attend meetings. So this is one of the reasons that if you typically conduct your meetings, you know, virtually, your annual meeting at the very least should be a hybrid. So you should have a physical location for your annual meeting, as well as, you know, allow owners to participate remotely via Zoom or whatever other virtual platform you use. Because again, physically handicapped persons are entitled to attend meetings. And also, as Alan may have explained, the elections are open until the outer envelope of the election ballot is sliced open. So at any point up to that slicing of the envelope, an owner could come in, you know, with his or her ballot, and you have to accept it. So there has to be a mechanism to do that. So you have to have a physical location. Like I mentioned, your election will have to be conducted on the date of your annual meeting. Now, in addition to the annual meeting, you might have special membership meetings, right? And a special membership meeting may be called by the board, for example, if there are issues that owners need to vote on. Okay, a membership meeting, again, just to clarify, a membership meeting is only a meeting where owners get to vote. So if you really are just reporting, right? Committee reports, reports of officers or directors, that's not a membership meeting. You're reporting, but it really is a board meeting at which you're just, you know, letting owners know of the, you know, the state of affairs in the community. So a membership meeting is only noticed where owners need to vote. And the board can call that membership meeting. For example, if you're looking to get amendments passed, owners need to vote on that. If you're looking for owners to vote to waive or partial fund reserves, again, that would be a membership meeting that you would need to call. Or a membership meeting can be called upon the written request of at least 10% of the unit owners, unless a different percentage is provided in your governing document. So owners do have the option of also calling a membership meeting if they want owners to vote on something. Okay, and if you get a petition, then yes, you're going to have to notice a membership meeting. All notices of all membership meetings have to include an agenda, and have to be either mailed, hand delivered, or electronically sent to any owner who has consented to receiving notices electronically, as well as posted on condominium or association property at least 14 days prior to the meeting. Now, if your bylaws require a longer period, then you go with the time frame provided in your bylaws. Otherwise, at a minimum, it's 14-day notice. The board must adopt a rule to designate a specific location on the condominium or association property at which member meeting notices will be posted. If you are mailing notice of a membership meeting, it must be mailed to each owner at the address that was last furnished to the association. Proof of notice with any membership meeting notice, you've got to make sure that you have an affidavit signed by the individual that provided the notice, attesting that the notice was properly and timely sent out. Unless an owner waives in writing the right to receive notice of the annual meeting, such notice must be hand-delivered, mailed, or electronically transmitted. And then in lieu of or in addition to the physical posting of membership meetings, the board may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed-circuit cable television system that services the association. So if you are a community that provides bulk cable services to the owners and you have a closed-circuit cable system, then that could be an option for you as well. The board just needs to adopt rules to that effect. Okay, with electronic notices, again, the association can opt to deliver meeting notices electronically. But again, the owners have to opt into the system. So the owners have to consent in writing that they want to receive official notices from the association electronically. Okay, if an owner does not consent in writing, okay, then, and you happen to have the owner's email address, well, you could email that owner a courtesy copy of the notice, but that emailed copy of the notice would not constitute as the official notice. You would still have to either hand deliver it or mail it as the as its official notice. The owner has to sign a written consent. And the consent can be delivered to the association either electronically, hand delivered, or can be sent by mail. If the owner opts into receiving notices electronically, well, the owner then bears the risk and the responsibility of ensuring delivery, that their email accepts association emails. Now, electronic notices cannot be used for recall of directors or for any vote to forego retrofitting of the sprinkler system. And then notices of meetings, they are effective when sent by the association, regardless of when notice is actually received by the owner. So if an owner tells you they have not received notice of the election meeting, well, you've complied as long as you can attest through the affidavit that notice was properly and timely sent. And then an owner who consents to receiving notices by electronic transmission is solely responsible for removing or bypassing any filters that block receipt of the emails. The association is required to maintain the email addresses or fax numbers for those owners who consent in writing to receiving notices electronically. Just a caution that if an owner does consent to receiving notices electronically, well, that email address or that fax number then does become accessible to other unit owners. So if if an owner does not want their email address to become accessible to other owners, well, then just don't consent to receiving notices electronically. That's the best word of advice. Otherwise, the association does have to comply with records inspection requests. And if you consented to receiving notices by email, well, guess what? That email now has to be disclosed to any owner that requests email addresses through a proper records inspection request. The association has to ensure that email addresses and fax numbers are only used for business operations, obviously. And the association cannot sell or share these email addresses or fax numbers with outside third parties. Now, again, with websites, with associations with 150 units or more, you also have an obligation to post a digital copy of the members' meeting notice and the agenda at least 14 days before the meeting. And then if there is any document that is connected with the owner vote, then you also have to post that on the website at least 7 days before the meeting. For those associations that are managing condominiums with less than 150 units, well, you have the discretion of posting the member notice, the notice of members meeting and document on the website. But as Alan mentioned, this website requirement is going to be changing. So make sure that you comply by the date that you're required to. Now, as far as quorum requirements, unless there's a lower number provided in your bylaws, the quorum requirement for membership meetings is going to be a majority of the total voting interest. Now, if you as a board feel that that is too high of a threshold and you want to reduce the quorum requirement for membership meetings, and I've seen it as low as 30%, well, that is an option, but you're going to have to amend the bylaws, and that will typically require membership approval. But you can't have a lower quorum requirement if it's provided in the bylaws. Now, unless otherwise provided in the statute or in your governing documents, decisions made by the membership must be made by a majority of the voting interest represented at a meeting at which a quorum is present. That's unless, of course, your documents require a different threshold. So, for example, if your declaration requires a vote of 75% of the owners to amend the declaration, then you got to go with the 75% vote. If the statute, for example, requires a vote of a majority of the voting interest to reduce or waive the non-SERS reserves, then that is the vote that you need to get, not a vote of the majority of the quorum. Just to give you an further clarification of what a majority of quorum means, or majority of the voting interest represented at a meeting. Again, let's take the condominium association with 100 units. And let's say your quorum is a majority of the voting interest, which is 50% plus 1. So quorum is the minimum number of owners that have to show up at a meeting in person or by proxy in order for the association to conduct, business that's set forth on the agenda. So let's just say your majority of the 100 units show up at this meeting. That's 50% plus 1. Majority of quorum means that if 50% plus 1 is the minimum number of owners present, then the vote that you would need would be a majority of those 50% plus 1, not a majority of the 100. Okay? Let's say 60% of the units show up in person or by proxy. So you've exceeded your quorum, right? So 60 units are present in person by proxy. Majority of quorum now would mean you would need a majority of the 60 that are present in person or by proxy, not a majority of the 100. So the more people that show up at the meeting, the higher your voting threshold. Now, written consent is an alternative option of getting owner votes. So one way is, as we've been discussing, to get owner votes at a meeting that is duly noticed in advance, right? And with your notice, you would typically mail out a limited proxy, and we'll talk about proxies momentarily. So owners who cannot attend a meeting, they can vote by limited proxy, right? They'll fill out the limited proxy and then send it back. That is one way. In lieu of having owners vote at a meeting, if your governing documents provide, authorize, and that's typically, you'd find authority in your bylaws, you could have owners consent to an action by written consent form. Okay, so essentially with the written consent, it's almost like a limited proxy. It could be in a form of a memorandum, and you'll mail this out, this document to the owner saying, this is the action that we want owners to take. Let's just, for purposes of this example, assume you're trying to get amendments passed. So on this memorandum, you'll send to the owners, you'll say, the board has drafted these amendments that we want owners to approve. If you are in favor of these amendments, please sign at the bottom of the form, please sign your consent and return it to the association. So only owners who are in favor of the action would need to return the executed written consent. Owners who are not in favor, opposed to the action, don't have to return the consent form. Now, those consent forms are, you have 90 days from the date of the first executed consent form to get the consents or the votes that you need. Okay, so it's very similar to a limited proxy, but you don't have to conduct a membership meeting. So for many, that certainly provides way more flexibility, especially if you're in a community where you have a lot of snowbirds who are gone, half a year or most of the year. And again, you can only take owner's votes or owner's consent form through this process if you have specific authority in your governing documents allowing you to do it this way. Now, members have the right to speak at membership meetings with regard to all agenda items. And the association does have the ability and really should adopt rules governing the frequency, duration, and the manner of owner statement. So if you haven't done that, probably a good idea, and get with your legal counsel to assist in drafting those rules. Now, members can also record and videotape meetings, and they are subject to reasonable rules adopted by the division. So for example, only audio and video equipment that does not preclude distracting sound or light emissions can be used. If adopted in advance as a written rule by the board, audio and video equipment must be assembled and placed in position in advance of the meeting. So here, the rest is just a list of other rules that the board can adopt with regard to video recording of meetings. Now, voting by proxy, there's two types of proxies that you will have. There's a general proxy and there's a limited proxy. The general proxy allows a proxy holder, the owner, to vote. However, allows the proxy holder for the owner to vote however the proxy holder sees fit on any matter that's undertaken at the meeting. A limited proxy allows the proxy holder to vote on specific issues that are specifically identified on the limited proxy. So, both can be used to establish quorum, and typically a general proxy would only be used for a membership meeting where you don't really have any specific items that you need owners to specifically vote on. Because if owners need to vote on, you will and should be using a limited proxy. In fact, the statute says that you need to use a limited proxy for the items identified here to vote on waiving or reducing reserves, to vote on reducing the financial reporting requirements, votes taken to amend your governing documents. These are all items that, or votes that you can only obtain from the owners through a limited proxy. Now, a proxy cannot, whether limited or general, cannot be used to vote in any election or to vote to retrofit the fire sprinkler system, right? So with elections, as Alan mentioned, you need to vote through through an election ballot with the inner and outer envelope. The proxy is effective only for the specific meeting for which it was originally given and any lawful adjournment of the meeting, but in no event can a proxy be valid for more than 90 days. So essentially, when you mail out limited proxy out to the owners in connection with a specific vote that you want them to take, okay? And let's say on the date of the meeting, you count your limited proxies and you just don't have enough limited proxies or votes in general that you need to pass a specific action. Well, again, these limited proxies are good for 90 days. So as a practical tip, what you'd want to do rather than adjourn the meeting, which would end the meeting, you would make a motion to recess and reconvene the meeting, and you can do this as many times as necessary up to that 90th day period, at which point the proxy will expire. So you can take a motion, you can, as long as you get a second, you have to get a vote of the majority of the owners who are present at that meeting to recess and reconvene that meeting. Okay. And if you get the vote, then you got to make sure that you announce the date of the reconvened meeting. So have already a date in mind and make sure that the minutes of your meeting reflect that new date and time. And then it depends on what your documents provide. You may or may not have to provide, another notice of that meeting. As a practical tip, it doesn't hurt to just, post notice of the date and time of the reconvened meeting. Now, in that time period, you can, knock on doors, send email blasts, send out newsletters, trying to, encourage owners to submit their limited proxies. And then when that meeting date comes, then you go ahead and you tally all the votes, and limited proxies that were submitted at the initial meeting, they're still good for quorum purposes, and you will be counting them towards the total vote that you need, okay? Now, once you get the votes that you need, you'll make a motion and you'll adjourn the meeting, and that ends that meeting. But as long as you haven't received the votes that you need, don't adjourn the meeting. You use those 90 days. And then every proxy is revocable at any time at the pleasure of the member who's executing that. All right, let's quickly move on to board of director meetings. So board of directors, fiduciary duty. Officers and directors have a fiduciary duty responsibility to the owners and must act reasonably. So it doesn't mean that you can't make mistakes. You just have to exercise your best effort in managing, operating the association, and certainly rely on advice and guidance of your professionals, your accountants, your engineers, your attorneys. Now, directors must not be compensated unless otherwise authorized in your bylaws, unless it's work performed in one's trade, with all the conflict of interest disclosure being properly made and abstaining from all decisions regarding that particular contract or transaction. And we'll talk about conflict of interest momentarily. Now, important to note, again, and Alan may have already mentioned this, but the board makes decisions as a board, right? Because the board is the one that is responsible for carrying out the association's duties. So no individual board member, not even the president, should be making unilateral decisions, right? unless the board has already authorized and delegated certain powers to the individual director, or unless there's an emergency. The next slides pertain to kickbacks. Officers, directors, managers cannot solicit, offer to accept, or accept any kickback. And a kickback is defined in the statute as anything or service of value for which consideration has not been provided. Any officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback commits a felony in the 3rd degree. However, these kickback restrictions do not apply or prohibit an officer, director, or manager from accepting services or items received in connection with trade fairs or education programs. So if you do attend these trade shows or expos, you are allowed to eat and receive goodies from the vendors. Alan already mentioned this, but the association, its officers, directors, employees, and agents may not use a debit card, right? So no debit cards. And then any person who uses a debit card issued in the name of the association for any expenses not lawful, that are not lawful obligation of the association, commits theft and must be removed from office. A director or officer who is charged by information or indictment with any of the following crimes must be removed from office. We've identified what they are: forgery of a ballot envelope, theft, embezzlement, destruction of or refusal to allow inspection and copying of the official records, obstruction of justice. And then if a director is removed from office on any one of these bases, and hopefully you have documented evidence of any of the foregoing, then the board must fill that vacancy until the end of the suspension period or end of the director's term. And if these charges are resolved without a finding of guilt, then the director or officer must be reinstated. The director or officer who has such charges pending may not be appointed or elected to a position as a director. So essentially 6 ways that you can get off the board. Certainly you can resign in writing. If you are also an officer, make sure that you make it clear that you are resigning not only as the officer, could be a treasurer or president or whatever your officer position is, but you're also resigning from the board. Recall is another way that a director can be removed. Delinquency, if a director is delinquent in the payment of any monetary obligation due to the association for more than 90 days, then they're deemed to have abandoned their seat. Then there's criminal charges involved with theft or embezzlement, or for knowing or willing violation of the Condominium Act. The division can order the removal. And then certainly if you fail to satisfy the certification requirements. Meetings of the board. When does a meeting of a board become a board meeting? Well, we'll talk about that in a minute. Effective July 1st, new statutory requirements for board meetings have come into effect. So if your condominium association managing more than 10 units, you now have to have at least 1 meeting each quarter. And then at least 4 times each year, which could be, once a quarter, or however you want to structure your meetings, but at least 4 times each year, the meeting agenda must include an opportunity for members to ask questions on the board. So you should have a special, a designated agenda item for member questions. Now, the statute doesn't necessarily require boards to answer those questions or respond to those questions, but you have to at least give owners the opportunity to ask questions. Now, there could be circumstances where the board has to take action, typically in an emergency, outside of a board meeting. Okay. Should that happen, don't panic. There is a way to basically correct that by ratifying the board action at the next duly noticed meeting. So you'd want to include on that agenda item, basically, ratification of whatever the action was that you took outside of a board meeting. Now, don't get in a habit of just ratifying board action after you've taken action, right? It should be on a limited basis. Now, board members can use email as means of communication, so you can send emails and chat about certain things. You just cannot use emails to cast a vote. So with board meetings, really the statute provides two basic notice requirements. More likely than not, and most meetings will typically require only 48-hour posted notice, right? So all meeting notices are going to identify the date, time, location of the meeting, all agenda items, and then typically you'll post notice of that meeting at least 48 hours prior and you'll post it on condominium association property where you normally post meeting notices. The statute does require at least 14-day notice for certain specific types of board meetings, and that is if you're going to adopt a non-emergency special assessment, or you're going to amend or adopt rules regarding unit use, not use of common elements or facilities, but regarding unit use, okay? Then that notice of that meeting has to be either mailed, delivered, or electronically transmitted to owners at least 14 days prior to that meeting. Now, you might have a longer notice requirements in your bylaws. Always check. If so, you obviously are going to go with a longer notice requirements. Otherwise, the statute provides 14-day notice for these types of meetings, as well as a requirement for the individual who provided notice to sign an affidavit attesting that notice of that meeting was properly and timely sent. As with membership meetings, the board has the option of adopting a rule to provide for posting and broadcasting the notice and agenda of board meetings on a closed circuit cable television system. For condominiums with 150 or more units who are required to maintain websites. Again, you also have the obligation to post a digital copy of the board meeting notice and agenda at least 48 hours or 14 days prior to the meeting, depending on the type of meeting you're having. Those with less than 150 units, and if you maintain a website, well, you have the option of doing that. Board meeting notices must specifically identify all agenda items. Okay, I know sometimes boards have the habit of identifying, new business as an agenda item. If you know that you're specifically voting on the budget, identify that. So you can have, new business and then identify what that new business is. Number one, adopting, the 2025 budget. Number two, adopting, rules concerning, use of the pool, whatever it is, identify those agenda items. Now, it could be that, you're talking, you're at the board meeting and, all of a sudden you remembered, oh, there's one additional agenda item that you wanted to discuss, but it's not necessarily, it wasn't reflected on the notice that was, posted or mailed out. The statute allows the board to add an agenda item at that meeting on an emergency basis, provided at least a majority plus one of the board members approves the addition of the agenda item. If you get the vote of the majority plus one, then you can go ahead and discuss and take action on that additional agenda item. Just note that you're gonna have to ratify that action at your subsequent board meeting. So make sure that you properly then notice the board meeting and include ratification of that item on the agenda. Now, if 20% of the voting interest petition the board to address a particular item of business, okay, then the board has to then conduct a board meeting and address the particular item within 60 days of receiving that petition. And you can add that specific item on the agenda of your regular or special board meeting. Another new statutory requirement that took effect July 1st is that if the board is going to be approving a contract, well, a copy of the contract has to be provided with the notice of the board meeting at which you're going to be approving that contract. So if you know, if all you're required to do is provide 48-hour notice of the meeting at which you're going to approve this particular contract, then you're going to have to figure out a way to at least post a copy of that contract somewhere on association condominium property, along with your notice. If you're going to adopt a special assessment, well, the statute says that notice of the meeting at which you're going to be adopting a special assessment has to specifically state that you're adopting the special assessment. You have to identify the estimated cost of the special assessment and then provide the description or purpose of the special assessment. Meetings of the board at which a quorum is present are open to all unit owners, okay, except for meetings between the board and the association attorney, as long as you're discussing proposed or pending litigation and you're getting legal advice on that, as well as meetings held for purposes of discussing personnel matters. Okay, these are the two types of meetings that are not accessible by owners. You're still going to notice the meeting. Okay, so you're still going to indicate, you know, the date, time, location of the meeting, but you're going to indicate also that it's a closed meeting, either to discuss personnel matters or closed meeting with legal counsel. Again, owners can also tape record and videotape meetings of board of directors subject to reasonable rules adopted by the division, and the board can certainly adopt these rules in advance of the meeting. With regard to videotaping and recording. Owners have the right to speak at meetings with reference to all designated agenda items. And the new statutory changes took effect July 1st. They also have the right to ask questions relating to reports on the status of construction or repair project, as well as the status of revenues and expenditures during the current fiscal year and other issues affecting the condominium. If you haven't done so already, certainly recommend that you get with your legal counsel to then adopt reasonable rules governing the frequency, duration, and the manner of owner statements. Quorum for the board will consist of a majority of the board. Now, board members can meet not only physically in person, but can also meet, via telephone, speakerphone, or virtually via Zoom or any other virtual platform, as long as there is an ability to hear the speaker. And the board members' presence at that meeting, you know, via an electronic virtual platform or, you know, speakerphone will count towards quorum. As far as voting, unless provided in the statute or unless your governing documents provide otherwise, action by the board will constitute a majority of the directors present at a meeting at which a quorum has been attained. Directors, as a general rule, cannot vote by proxy or by secret ballot. So the only time they can do vote by secret ballot is when they elect officers. And the secret ballot can be, a posted note. But that really is the only time that they can vote by secret ballot. A director who's present at a board meeting at which action on any corporate matter is taking is presumed to have assented to the action unless he or she votes against the action. A director who abstains from voting on any action taken on a corporate matter is presumed to have taken no position. And then a vote or abstention of each director must be recorded in the minutes. And as a practical tip about minutes, minutes should not be a transcript of, what everybody discussed. Okay, the minutes really should just reflect, who was present at the meeting, the motions that were made, who seconded the motion, and then the vote that was taken on the particular motion. Okay, putting too much information on these minutes could potentially subject the association to liability. So make sure you don't, transcribe the entire meeting in your minutes. For committee meetings, okay, if a meeting of a committee is to take final action on behalf of the board or to make recommendations with regard to the association budget, those committee meetings are always subject to the meeting notice requirements. You cannot exempt them from those meeting requirements, which means they either need to be posted 48 hours in advance or be mailed out 14 days in advance. If it's a meeting of a committee that is not a meeting to take final action on behalf of the board or to make recommendations to the board regarding the budget, they can be exempted from the notice requirements, but only if you amend the bylaws and specifically exempt these meetings in the bylaws. So you have to have an amendment done, and then owners will have to vote on the amendment. Otherwise, all committee meetings need to be properly noticed, just like you would with a board meeting. All right, insurance requirements. All right, so condominium associations have to use their best efforts to obtain and maintain adequate insurance to protect the association property, common elements, and condominium property that the association is required to maintain. Now, what is adequate property insurance? Well, adequate property insurance is going to be based on the replacement cost of the property that's to be insured, which has to be determined by an independent insurance appraisal or an updated appraisal. And that replacement cost has to be determined at least once every 36 months. So you're going to have to get an updated appraisal every 36 months. Okay, and your insurance premium is going to be based on that. The statute does provide an option for associations to self-insure, but let me just say, it is a very complicated process, which is why virtually no condominium association self-insures. Okay, so you're still required to maintain and obtain and maintain adequate insurance for your condominium. Associations should also have liability insurance for directors and officers, and that is called D&O coverage. And it typically covers directors and officers from, negligent acts and omissions. So if you don't currently have this type of insurance, you definitely want to get with your insurance agent to confirm whether you have this coverage. And if not, get that coverage, because that would kick in if the association is ever sued for, potential breach of fiduciary duty or negligence of any director. That's the insurance that's going to kick in, not necessarily your property damage insurance. And then you will also have insurance for flood insurance for your association and condominium property. Certainly if you are in a flood zone and are required to do so, but You may also want to discuss the option of getting flood insurance with your insurance agent, even if you're not in a flood zone. The statute also requires associations to maintain what is known as fidelity bond. And the fidelity bond is intended to cover any person who controls or disburses funds of the association. So in an example, and this is a very real example, where you have a treasurer or any other directors who, embezzle funds, okay? It's the fidelity bond coverage that's going to kick in and provide coverage for that embezzlement. Now, the statute says that the fidelity bond is supposed to cover any person who controls or disburses funds. That includes, but not limited to, anyone that is authorized to sign checks, the president, secretary, treasurer, even your property manager. Okay. And the fidelity bond must cover the maximum funds that will be in custody of the association or your management agent at any one time. All right, so it's not just any arbitrary amount. It's going to have to cover the maximum funds they'll be in custody. Obviously, this is a cost that the association has to bear, and it's a common expense of the associations. Now, effective July 1st of 2024, if the division receives a complaint, the division will monitor an association for compliance with the statutory insurance requirements and may issue fines and penalties established by the division for failure of an association to maintain the required insurance policies or fidelity bond. Okay, so the division is taking your insurance responsibilities very seriously. Now, every property insurance policy that's issued or renewed after January 1st of 2009 for the purposes of protecting the condominium must provide primary coverage for these two things. Basically, all portions of your condominium property as originally installed or replacement of like kind and quality, and then any alterations or additions to the condominium property or association property. The only property that is excluded from the association coverage is what unit owners are responsible to insure, which is in the next slide. So associations insurance coverage will exclude all personal property within the unit or the limited common elements, and then floor, wall, ceiling coverings, electrical fixtures, appliances, water heaters, water filters, built-in cabinets, window treatments, curtains, drapes, blinds, hardware, and similar window treatment components and replacement of these items. So these items are specifically unit owner responsibility, not association responsibility to insure. Okay. Now, at some point, the statute did have a requirement for owners to maintain insurance covering these items that we've just talked about. That requirement was removed. Okay, so the ability of the association to then place insurance coverage on the owners, that was eliminated. There is presently nothing in the statute requiring owners to maintain this coverage, unless, of course, your governing documents specifically require that. Most documents, especially the older associations, for older associations, do not have this specific requirement. But speak with your legal counsel if this is something that would be in the best interest of the association for your community. Unit owners are responsible for the cost of reconstruction of any portion of the condominium property for which property insurance and the cost of any such reconstructions done by the association is chargeable to the unit owner and may be enforced and collected as an assessment. So let's talk about what happens when there is a casualty event. And a casualty event is basically an event, an unexpected event that would be covered under your insurance. So typically, hurricanes, active, not active, but, you know, sudden water leaks. Typically, these are insurable events. So any portion of the condominium property that must be insured by the association, if it is damaged by an insurable event, then that damage has to be repaired, reconstructed by the association as a common expense. Okay, so if any associations out there were recently affected by Hurricane Helene or Milton, and you sustained a damage to any common elements, that was likely an insurable event. You're likely have already placed your insurance agents, insurance carriers on notice. You've already had, I'm sure, an adjuster come out. You, the association, are responsible for addressing that hurricane damage as a common expense. Now, there could be instances where an owner is responsible for the cost of reconstruction. Owner would be responsible for reconstructing any portion of the condominium property for which the owner is required to maintain property insurance. So the items that we discussed in the previous slide. And then certainly if any damage to the condominium property is caused by the intentional conduct or negligence or failure to comply with the governing documents by the owner, okay, then that owner would be responsible for the cost of reconstruction. The work would still the work would still have to be performed by the association if it's damage to condominium property that the association insures. But then once the association repairs the damage, if this damage was caused by the owner's negligence or intentional misconduct, then there could be a basis for the association then to seek reimbursement from the owner. Now, in the absence of an insurable event, so if the damage did not result from an insurable event, okay, then you are going to have to look at the maintenance obligations of your declaration to see which party is responsible for what. Okay, so if an owner was doing renovations within the unit and inadvertently negligently burst a common element pipe, which caused damage to condominium property, unlikely that that would be an insurable event. So then you'd have to look at the maintenance obligations of the owners and the association that's in your declaration to see who's responsible for addressing what. And if there's an ability to recover against the owner as a special assessment. All right, we're at the last section. We've got about 15 minutes. Conflict of interest. So directors, officers, and relatives of these directors have to disclose to the board any activity that may be construed as a conflict of interest. Well, the statute tells us what a conflict of interest is. And there's a presumption that there's a conflict of interest if this director, officer, or relative has entered or wants to enter into a contract with the association, or this director, officer, or relative have an interest in an entity that is looking to enter into a contract with the association, right? So if either of these two things occur, well, that's a conflict of interest, and there's specific disclosure requirements. So it's not that the statute prohibits these contracts, is that there's a certain a procedure for approving these contracts, okay? And what the statute requires is that the proposed activity or the proposed transaction that the director wants to engage in, so whether it's director, officer, or relative wants to enter into a contract with the association, or it's an entity that they have an interest in, that transaction has to be reflected on the notice and the agenda of a board meeting at which this needs to be discussed. And then the vote that you're required to get to approve that transaction or contract is a 2/3 vote of the other directors present. Obviously, the interested director has to has to abstain or recuse themselves from the vote. And it would be the 2/3 of the remaining directors that would have to approve the action. Now, the director, officer, or relative who is the interested party in this transaction, they can attend the board meeting and they can do their presentation. And then once they do their presentation, they basically have to leave the meeting while the remaining board members discuss and vote on this proposed transaction. The attendance then of the interested director or officer will count towards the quorum requirement that you would need to for the board to conduct the meeting, even after that director or officer, leaves the meeting after their presentation. If the board decides to vote against or disapprove the proposed activity or transaction, then the interested director, officer, or relative has to notify the board in writing of their intent not to pursue the proposed activity, or they're going to have to withdraw from office. Now, another important step to this, and this is the part that most boards miss, is that at the next regular or special meeting of the unit owners, the board has to disclose this contract or transaction, okay? And then the board, the members, by a vote of the majority of the members present, can vote to basically cancel the contract. And if the owners end up voting to cancel that contract, that transaction, then the association is only liable for paying for the goods and services rendered up to that date of cancellation. And if the contract happens to have any cancellation fee or penalty for canceling early or a liquidated damage clause, then the association would not be subject to that termination penalty. Now, if a contract between that director, officer, relative, and the association exists and that was not properly disclosed, then that contract is voidable. That means that the contract can then be terminated by the board as long as they obtain the vote of at least 20% of the voting interest of the association. And then again, for those associations that are required to maintain websites currently, a copy of that contract does have to be posted on the website. And then finally, the conflict of interest statute was also, the statute was amended to include conflict of interest provisions with regard to your community association manager and management firm. So this took effect July 1st, and it now reads that essentially your association manager or that your management firm, including any director, officer, or persons that have a financial interest in the management firm, or any relatives of these individuals, they also have to disclose to the board any activity that can be construed as a conflict of interest. And just like, the definition of conflict of interest in the previous slides, there is a rebuttable presumption that a conflict of interest exists. Again, if your manager, management firm, or any director or officer of the management firm enters or wants to enter into a contract with the association, or any of these individuals have an interest in an entity that is looking to enter into a contract with the association. So again, that proposed transaction would have to be identified on the notice and the agenda of a duly noticed board meeting. The disclosure of the conflict of interest has to be reflected in the minutes. And again, the vote that you would need to approve that proposed contract or transaction with the conflict of interest is a vote of 2/3 of all the directors present. And then also you'd have to disclose this contract transaction to the membership at their next membership meeting. Now, if the CAM or if the manager or the management firm previously disclosed this conflict of interest in an existing management contract, right, that was entered between the association and the management firm, the conflict of interest does not need to be additionally noticed and voted during the term of that management contract. And most of the new management contracts that I've seen contain some kind of disclosure already. So if it already identifies all these disclosures of entities that they're in which the manager or management firm is affiliated with, well, again, you don't need to go through this approval process as long, during the pendency of this management contract. However, once that management contract is up for renewal, then yes, you have to go through this voting procedure to approve that transaction or conflict. If your management company or the manager has violated this section, then the association can cancel the management contract, essentially, without any penalties, without having to pay any termination fees or liquidated damages. And then failing to disclose this conflict of interest also now constitutes grounds for which disciplinary action may be taken against the property manager or the management firm. All right. That was it.
Well done. Welcome back, Alan, as well. And we placed the link. Kerstin's going to answer a few. There are a lot of questions with not a lot of time left, but we'll go over a few of them. But before we do that, this is the part now. You've done the required part. So the evaluation link is in the chat. Click on that link, fill out the evaluation. While we'd love for you to stay and listen to some answered questions, you can go. The required part is over. So fill out the evaluation, then you can head out if you choose to. So I'll go over the evaluation process again after the Q&A, and I promise I'll do it more slowly next time. But for right now, I'll turn it back over to Kerstin, Courtney, and Alan, who is back, if you want to address any of the questions that are in there now.
Okay, let's see. I'm assuming these are all new posted questions, right?
In the Q&A,
Q&A?
they're all after Alan's portion.
After Alan, okay. Let's see here. So we're in association with over $600,000 in receipt. How many years can you consecutively waive an annual audit? Well, again, the statute says you can't waive the audit in consecutive years. So you're going to have to skip a year before you can waive it again. Let's see. I have a vacancy due to a board member resigning for personal reasons. How long do I have before I must fill it by appointment? I mean, conceivably, you have until that the term of that seat expires. But check your documents. It might be written that you don't necessarily have to fill the vacant seat. In which case, I mean, as long as you have enough directors seated to constitute a quorum and it's not an even number to avoid an impasse, I mean, you could conceivably, operate till the end of that term. Let's see. How much liability insurance shall a newly elected condo board member anticipate? I mean, I really think that's more of a discussion that you should have with your insurance agent. Sometimes the governing documents might identify, the minimum threshold that you must maintain, but really this is more of a discussion for you to have with your insurance agent. Can a non-owner resident serve as a board member? That's going to be very specific to your governing documents. There's nothing in the statute that says that a director has to be an owner, but it's certainly a requirement that could be in your bylaws. So you're gonna have to confirm with your governing documents and make sure you check your articles of incorporation. A lot of board members just go straight to the bylaws, but in the hierarchy of documents, if there's a conflict between your articles of incorporation and your bylaws, your articles will control. And so, check your articles as well. Let's see. There was a question about a licensed cam is emailing owners without a release. Not sure what that release is about. Can't really answer that question. What is the board's authority to remove or ban owners from a meeting for unruly behavior? I've recently hired off-duty police officer to sit in a meeting to quell this behavior. I start meetings by affirming Robert's rule, but some folks are insistent on
Talking.
talking away beyond the 3 minutes allotted. Yeah, I mean, unfortunately, for some associations, that is a problem. You have these unruly owners. I mean,
Nah,
certainly
never, never.
off-duty,
Come on. Never. That never happens.
certainly off-duty police officer, could be an option, and sometimes a police officer will assert himself or herself and bring order. Sometimes, the officer has to remove that owner. I would say if you're documenting the behavior of this unruly owner at meetings, you might have a basis to have your legal counsel send a cease and desist letter to this owner. But ultimately it will require a court order to ban an owner from a meeting. And you would need substantial documentation of unruly, nuisance behavior to support, that court order. So it's not
I've
easy.
actually had officers on detail, and when I
Yeah.
was on site at one time, I've had to do that too.
One more thing I've found helpful from the inception without even being in that meeting necessarily is adopting a policy that specifies how members are supposed to behave during the meeting. When you say Robert's Rules of Order, that tells me that you haven't thought about it and you're just kind of throwing out there whatever's in the bylaws. Robert's Rules are parliamentary procedure. They have no application, in my opinion, to an HOA or a condo board meeting or member meeting. So my position is you adopt rules governing the behavior that is required of the members during those meetings. And if someone is not behaving in that manner, then like Kerstin said, you can have them removed from each one of the meetings. And frankly, if you don't want to go to the extent of getting that court order, just have a police officer that's off duty show up at every single meeting, or have your attorney show up at every single meeting. And basically I've attended meetings where I had the board authorize me on the spot to file a lawsuit because the person was interfering with the business of the association. Not that I could file that lawsuit within 5 minutes, but authorizing me when I get back to the office to draft the lawsuit to be filed in the court. And this is not necessarily a covenant enforcement issue, so it could be addressed differently. But Kirsten, I'll turn that back to you.
Nope. Well, that's good advice. Can we require minimum credit score? Not necessarily on topic of what we discussed, but in order to, you could, provided you have authority in your governing document. So that is something that's going to be very specific to your community. Are there any ceilings and attorney's fees related to documents? Not even sure what that means. I think if you're looking to, overhaul your governing documents, certainly we're experienced in doing that. We're happy, either one of us happy to discuss that particular document project. Once we have governing documents, we typically can provide a not to exceed amount, but there's nothing in the law that I'm aware of providing a ceiling.
If you're talking about attorney's fees and costs for the records inspections where you don't produce it, and I mentioned that you're entitled to attorney's fees if the association doesn't produce them, the only cap that really exists, and frankly in any litigation, the only cap that exists is what a judge finds reasonable. That's really the only limitation.
Mm-hmm. If a unit owner fails to pay a fine, does the failure allow the board to suspend use rights for delinquency? Certainly. I mean, unpaid fine becomes a monetary, a delinquent monetary obligation to the association, which, as long as it remains unpaid for more than 90 days, yes, you can go through the process of suspending use rights. Let's see what else here.
Let's do like one or two more, and then we're probably going to use a lot of these questions to produce an after show at some point very, very soon. So folks, if your question doesn't go answered and if it's on topic and pertinent, we're going to record an after show and we'll let everybody know when that takes place. We know 4 hours is a long
Treasurer
time.
reports, is there a requirement in Florida statute to provide owners with a written report of any kind, or is it acceptable to verbally discuss all relevant variances at monthly board meetings along with other financial matters? I mean, other than providing a copy of the proposed budget in advance of the meeting or a copy of the financial report when it's due, there's no requirement for you to provide, reports. You can certainly report at the meeting. Let's see, one more.
Mhm.
If your condo docs specify a 30-day notice of a board budget meeting, does that supersede the state's 14-day requirement? I would say in an abundance of caution, yes, go with the 30-day notice requirement in your bylaws.
Okay.
That's it. I'm sorry, couldn't get to, woo.
You kidding me? You sorry? It's only 200 slides. What are you talking about? You both did a fantastic job. And before you head out, and folks, I will go over the evaluation process slowly. I'll open up the chat so you could ask me technical questions on that. Before we do that, before I share my screen on that, I want to go around. I'm going to do some Brady Bunch pointing, like the Brady Bunch screen. We're going to do one by one. I want Courtney, some final words. Alan and Kerstin, how can you all be reached? And then I'll come back and do the evaluation instructions one more time. So Courtney, how about you first? A little bit, how can you be reached? The best way to get in touch with yourself and the fine folks at GRS Management.
So you can get in touch with me by email. That's the best way. My email is C as my first name, Courtney, and my last name, Buchan. That's spelled BUCHAN at grsmgt.com. Again, C Buchan at grsmgt.com. I'll even put out my work phone number. That's 561-941-4220.
All complaints go. No, I'm just kidding. Just kidding.
That's fine. And then if you want more information about our services here at GRS, you can go to our website, grsmgt.com. Just a quick thank you to Alan and Kerstin. You guys did a great job. That was a long one. I appreciate it so much. Thank you to all of our board members that attended. And I know, Jeff, you had mentioned this in the beginning. Next time or in the future for these classes that are accredited, you cannot be with a group of people watching, because I had an issue during the class where I was getting some emails back and forth. You have to individually sign on with your own username and login, and it has to be your name. Jeff, maybe you can comment more later after Alan and Kerstin, you can explain why that's needed. The division.
It was on the registration too. When you would go to register, it laid it all out right there that you had to register and use your own login credentials. So it was all right there as well. But I'll certainly go over it after I do the evaluation stuff.
Well, that was it. Thank you so much. That was great. Thank you, guys.
And how about you, Kerstin? The best way to get in touch with you and your location in Tampa?
Sure. I mean, as Alan mentioned, we provide services throughout the state of Florida. So we have 23, 24 attorneys throughout the state. But if you are local and you want to contact me directly, feel free to email me. I think the email is going to be on the survey, or you can call the office main number, which is 954-928-0680. And just like that, reception will connect me with you. So thank you so much for staying for 4 hours.
Absolutely. And thank you. Excellent job, Kerstin. Excellent. As always. And Alan, last but not least.
All right. Well, I see that people are starting to drop off when they saw that I was going to be the next one speaking. Thanks a lot, everyone. But for those of you that stuck around, thank you again for your time, GRS and Courtney in particular. Thank you, Kerstin. Thank you for taking 2 hours off of my plate, especially. Jeff, thanks for your help as always. Everyone that attended, you're welcome to reach out. I can most easily be reached via email. You'll have my email address once you fill out your survey. And LinkedIn is another place where I post very silly things once in a while, but primarily try to focus on things that are helpful for the community association industry. So feel welcome to follow me there as well.
Excellent. Thanks to the three of you. And Courtney, thanks for doing this with us. We appreciate you having us and inviting us to do this. Alan and Kerstin, I will speak with you soon and see you both next week. And you're all three of you are welcome to stay on, but I'm now going to start blabbing about
Thank you.
how to do the evaluation and answer technical questions. And you're welcome to stay, but I understand if you have to go. See you all soon.
Thanks, everybody.
All right.